Yes. Item number 29. 29. Okay. We'll try to take it up. $17. You want an upgradation? Okay. Okay, 17. What says it present? Okay, pair made by land transfer for the petitioner. List on 17, 11, 20. Okay. Item 57. 57. Yes. Okay, you have informed the other side. Okay, both sides are represented. Mr. Prayer is made on behalf of the learned CGC, seeking 2 weeks' time to file affidavit in reply in the matter. List on, give a date after 2 weeks. Hmm? 53. You want an upgradation? Okay. Four. You want an adjournment? You want to withdraw it? Okay. Please see if the speaker is open. I'm unable to hear it. It's open now?
My lord, I want to withdraw the petition
Okay.
with
Your
the
name?
liberty
Your name?
to file a fresh petition.
Your name?
A. Mohanta with senior T. Sob.
Both sides are represented. On the prayer made by Miss. Your name?
A. Mohanta.
Ms. A. Mahato, appearing on behalf of Ms. T. Som, London Council for the petitioner, seeks to withdraw this writ petition with liberty to approach again. Prayer is allowed. Matter stands dismissed on withdrawal with liberty as paid for. Yes.
May it please, your lordship. Lordships, I'd like to mention item number 20 to 24.
Item
20 to 24. Lordship, the matter may be adjourned for today, Lordship. The joint prayer, respondent is also here.
20 to 34.
20 to 24, Lordship, joint prayer.
On the joint prayer. Mr. Kyal, who's you are
Lordship.
joint prayer?
Lordship.
Okay. The joint prayer made by the London Council for both sides. The matter stands adjourned today. List after?
After 4 weeks, Lordship.
List after
New
4 weeks. Okay.
Lordship, there is an interim. Interim is there. Interim is there.
Interim order shall
Interim.
continue till the next date of listing.
Oblige, your lordship.
May it please, my lords. My lords, I'm appearing before my lords to beg mention to the fact that an unlisted matter has been filed, will be filed during the course of the day today. So my lords, I seek that the matter may be listed today itself. It's an habeas corpus
Unless it
petition.
is not numbered, it will not come. The
It's a
mention memo
habeas
will not go.
corpus petition, my lords. And
The mention memo will
Peti-
not go from here unless there is a filing number.
tomorrow, my lords, tomorrow, my lords,
Make a mention after the listing is made.
my lords, my lords. I'll
Definitely have to make tomorrow only.
oblige, my lord, oblige.
May it please, my lords, prayer for listing of a hearing matter, my lord. Yes,
Give it to the court master.
my lord, for Thursday, if it pleases.
We are not saying let the court master fix a
Deeply
date.
obliged.
Your lordship, I beg to mention item number 2. I want to withdraw this. Yeah, your lordship.
Item 2.
Yes.
On instructions. You are Mr. Vijay Das. Mr. Vijay Das, counsel for the petitioner, seeks to withdraw this PIL. So the government who is there, Mr.
Yes.
You are there, Ms. R. Boroborat, and government advocate is present. Matters still dismissed on withdrawal.
Much of
Please, your lordship, I beg to mention item number 58 and 59, your lordship.
58, 59.
Lordship, service is awaited, your lordship. That the matter may be list after a week, your lordship. 58 and 59.
There is an office note. What is the office note?
That is all. My steps were taken on the last Friday, your lordship. Uh, uh,
This writ petition is against surface action,
yes, your lordship.
but Supreme Court has said it should not be entertained.
Lordship, it is not against surface, your lordship. DRT matter, lordship.
Order of DRT is under challenge.
Yes, your lordship.
But then there's an appellate authority. Why we should exercise the jurisdiction or certiorari here?
Lordship. Lordship, can it be after a week, your lordship?
Okay. 58, 59. The learned counsel of the petitioner pays for an adjournment. Next para. On the next date of listing, the learned counsel for the petitioner shall address the court as to why this court would exercise jurisdiction when appeal against orders of the DRT is prescribed in the statute. List on, give a date next week.
Oblige, your lordship.
Just before that, like list on so you say.
Right.
In the meantime, the service report is awaited.
May I please, your lordship? Lordship, I beg to mention item number 15, my lord. So, but for today, my lord.
Item number
15, my lord. Amser Ali.
50
15, my lord.
15. Yes. You want an adjournment?
My lord.
Okay, 15. You have to just wait for some time. I am making a note. You renew the prayer when the matter is called.
My lord.
Because these are all pending matters. We'll just look into the records.
Oblige.
Item 14, Lordship, item 14 may be adjourned for 1 week, Lordship.
No, we'll just have to take up the file because
Yes.
these are all pending matters. We have to look into it.
Supplementary item 51, 50, 51, 52, delivery of order.
My lord. May I assist your lordship immediately? Yes, yes.
Item 1 for motion, PIL 52/25.
Not, it is regarding office of a development block. So instead of central place, my lord, though there is a communication, etc., better than the place in a remote area, my lord, they are going to construct this headquarter of the development block. That is the contention, my lord. The about 90%.
Something which is not, is beyond our
90%,
jurisdiction.
90% population will be affected by this shifting, my lord.
No, but there are, you see, this is not within our domain. It is for the executive to do it.
Yes.
And there is a judgment of this court in Itanagar bench. I forgot the judgment. I couldn't track it. And even the Supreme Court says that the changing of this block and all headquarters, it's not within the domain of the High Court.
No, my lord, but your lordship, I humbly submit before your lordship. Authority is to satisfy your lordship. Why shifting? My lord,
It's not required.
if it
It's
is,
the political opinion.
my
You
lord,
see, was there a referendum
my lord,
when the capital of Assam was shifted from Shillong to Guwahati? Did everybody vote for the shifting of capital?
my lord,
There was a bifurcation of a state.
shifting of capital from Shillong to Guwahati is another aspect, my lord. Meghalaya was
Why?
created at that time.
That's why.
So Assam capital is to come in the territory of Assam. That is another aspect of the matter.
No,
But
but
thing is
was
this,
there
my
a
lord,
referendum?
my lord.
Was there a referendum? No. There was no votes were cast for that. Where will be the capital? Where will be the
My
headquarters?
lord, but my humble submission before your lordship, that what place I am claiming for, my lord? What place I am claiming for? Which one is suitable for the public? That is to be looked into by the administration. My lord,
Then there will be no development.
my lord, that aspect your lordship will consider that whether if it is taken in our place, that the middle place of the area, territorial area, no development, my lord, how that will satisfy by the authority that if in a place, in central place, it is not, it is constructed that there will be no
Central
development,
place is always developed.
my lord,
Central place of
Right.
any town, any village
my lord,
is always developed.
my lord.
You show me one village in the country where the central locality is not developed.
So, my lord,
Remotest village.
I do agree with your lordship that there is a question of development, so in remote area it will be taken. But your lordship is to look into the infrastructure also, otherwise why the public will suffer? 90% public will suffer. Let them say, my lord, a question arises before your lordship. We raise a question. Let the authority say why, my lord, my lord. My lord, only thing is this, my lord. Your lordship will decide. After notice go, let them say what they want to say. My lord. My lord, already site has been decided by the authority. They visited the site, they decided on our representation that construction will be done here. But suddenly, my lord, it has been shifted to a corner place. My lord. Well, but notice is to be given, my lord. Thereafter, my lord. Well, only thing is this, my lord, there must be some reason why it is shifted to a corner. My lord. Well, in that case, my lord, let it be on some other day, my lord, let me see. No, my lord, what your lordship cited the example, but that is another thing. It is public, it is in the private domain, my lord, where I will start my shop. But thing is this, my lord, it is the public interest involved, my lord, yeah. Anyhow, my lord, on some other day, let me try, my lord. It's a date, sabak, what suppose later, no problem. My lord, next week. Next week, my lord.
The pain are ready.
10. Next Monday, my lord, 10. On 10/11, my lord. Obligation.
Yes, Lord. Holding center at Matia.
Hmm?
Yes, Lord.
Yes.
Matian tu khubur lo. Matian আছে?
FT Matters has produced written instructions dated 31/10/2025, wherein it has been disclosed that
Matia holding center. Police আছে তাতে।
that Mohammad Fajr Ali, FAJAR, Fajr Ali,
Order respectfully notified.
who was a declared foreign national as per opinion dated 18/7/2018,
Yes.
passed by the learned member, Foreigners Tribunal 6, Tejpur, in case number FEC 6/99/2018, para 3 last order, was apprehended on 24/5/2025 for verification and later on handed over to the holding center, Matia Gwalpara, on 25/5/2025. Next para, accordingly, court is inclined to grant visitation right to the petitioner as well as one of his family member by providing that on production of a certified copy of this order, the in charge of the holding center, Matia Gwalpara, shall permit the petitioner and one family member to meet the declared foreign national, namely, Muhammad MD, Muhammad Fajr, FAJAR, Fajr Ali, and to take a signature in the Wakalatnama. Next para. List on. Look at it after a week. Just before that, last line, instructions produced as retained on record.
Published.
Item 5 for motion.
Yes, Mr. Sheikh.
My lord, this is a peculiar type of case, my lord.
Yes.
What happened, my lord? Actually, tribunal decided that I am foreigner after 1971. But tribunal failed to decide to which country I originally belong. That is why, my lord, a problem arises. High Court dismissed my petition. I went to Supreme Court dismissed my petition. Now I am in detention camp, my lord, completed 118 days. Now what happened, my lord? When my country of origin is not decided, then the authority will deport me to which country? And if that is so, my lord, for indefinite period, I cannot be kept in detention. So, my lord, my humble submission before your lordship, on merit, I have nothing to say because it is already fought out up to the Supreme Court. But my point is this, my lord, how long I will be kept in detention? Because my country of origin is not decided. Your lordship would be pleased to see page 30. Page 38, my, oh, sorry, my, page 30. Opinion. Second paragraph. It is said, no doubt, that 25,371 I have entered India. But from where I have entered? It is not answered.
That answer will come under which provision of the Foreigners Tribunal's order?
Hello.
That decision is supposed to come under which provision of the Foreigners Tribunal's order? Because so far as I understand, this only says that the answer is to be as to whether he's a foreigner or illegal migrant,
My lord.
from which country he has come,
He is a foreigner.
that
He
perhaps,
is a foreigner. In that case, my lord, your lordship would be pleased to see. I am a foreigner. Belong to Afghanistan, Pakistan, Bangladesh, or this Nepal. That is to be decided. Otherwise, my lord, how the government will decide to which country I will be pushed back. And another question, my lord, if country is not decided, for indefinite period, I cannot be kept in detention. Because I already complete 118 days, no action from the government.
you were taken into custody when? What is the date you were taken into custody?
I was taken to custody, my lord.
On which date?
My lord. I'm giving my lord. My lord, your lordship will turn to page 13, para 16. Police arrested the petitioner on 19/12/2024. 19/12/2024. Page 13, para 16.
Yes, Mr. Sharma. What do you say?
Lordship, may dispose it of lordship, case has no merit at all, lordship, and a specified territory, already references said Lordship, he is coming from specified territory. That was dismissed by Honorable High Court as well as Supreme Court also, Lordship. So, Lordship has already decided in so many judgment, Lordship, already passed there. In the light of death judgment, Lordship, this also dismissed, Lordship, in limine, Lordship, not. There is no case at all, Lordship. Dada,
FIT,
Dada,
FIT.
Dada. Dismiss this one. Huh? About it. So, go for it, so, just compass. Dismiss.
Seven. Seven, 11, 25. For
Reference to.
Orders.
From specific territory.
we'll examine the record and pass orders. The date is fixed on 7th.
Sorry. Lord, it will be listed again, or,
Yes, it will be listed again.
yes, please. Obliged, Lordship. Obliged, Lordship.
But it will be for passing of necessary orders because till as of now that earlier record is not there. I'll peruse the earlier records and pass orders. Motion hearing has been concluded.
Obliged, Lordship.
Yes, item 6.
My lordship. My lord, the input opinion, my lord, is 63, my lord.
63.
But opinion of my lord 24 to 2022, my lord. But mean the fact, my lord, I am the regularly appear before the learned tribunal and the learned the court below, my lord, engaged counsel not ever informed to me, my lord. My lord, I stated in para number 19. And thereafter we file a complaint against the council, my lord. On
19.
I mentioned, my lord.
The para number
Killer is stated, my lord, para, my lord, 9, my lord. Base 11. And regularly I appear, my lord, but one, my lord, 21/7/2025 also appear. I also paid fees, my lord. And personally, I meet, my lord, the bench, my lord, on 19/8/2025. Then from the bench assistant, I come to know I was declared for a loan back, my lord. And immediately I file a complaint against the, my lord, state council, my lord, that pays 70, my lord. Before the bar, my lord. And I said 17 page 70, my lord. Completely, my lord, I am eligible. Is the, my lord, no, anytime, my lord, he was not informed me when the order was passed, my lord. And he was asked to me appear, accordingly I appear regularly, my lord, and pay also fees, my lord, as per. I also imprisoned party, my lord.
There's a bit of hand in glove. You see,
My lord.
this, in your writ petition, you have said somewhere that the proceeding had come and met you.
Yes,
You have given your name also, you sent that he met you, and then after that, this complaint comes. And you know that this complaint to a secretary of the association would not yield any result.
immediately, my lord, 38/2025.
You look at, somewhere you have said,
Immediately. So when we
yes,
got,
para 10. You said that in the second week of August, he came, met you.
yes, my lord.
And therefore, this complaint must be on the basis of some legal advice he has received. Now, a complaint to an association will not do anything. Your lawyer goes scot-free and you don't get that question to explain to us
My lord.
the delay.
And applied, my lord, 27.
We are not on that. The learned counsel for the petitioner has submitted that although the petitioner was regularly in contact with her learned counsel, but the information was not passed, was not given that the opinion had already been passed. And therefore, the petitioner had also filed a complaint before the Lawyers Association against the conduct of the learned counsel. Next, in view of the said explanation, comma issue notice returnable on so and so, extra copies with including call for the records. Prayer for bail shall be considered on receipt of records. Next, in the meantime, if the petitioner, namely so and so, alias so and so, is apprehended, comma, he shall not be deported out of the country without order of the court. Next, the petitioner shall cause production of a certified copy of the order before the Superintendent of Police border,
Bugolpara, my lord.
Guapara, to bring the order to the notice of this.
My lord. My lord, step regarding my lord, respond number 7, my lord, that part. Private respondent, we made party.
You issue notice to him?
Yes, ma'am.
See then.
Hello, sir.
Item 7 for motion.
Wait, please, your lordship. My lord, by
Doesn't
this,
coincide with our bench.
my lord.
The matter doesn't coincide with our bench.
I think lordship needs a change also.
At times, yes.
And subject is very interesting, my lord. Now, what had happened, lordship knows, this 1964 Act, I'm giving a brief account of the scheme of the 1964 Act. Is basically a power given to the state to requisition a property. And that is under section 3. Then under section 6, following requisition, they may also acquire. And by invoking section 8, in the event the purpose is served, then the land can be released.
Just a moment before you begin, there's a query so that you can answer when you
Yes,
make your submissions. You see, there has been various interpretations, including interpretation by the Supreme Court,
Yes.
saying that whatever be the land laws, even we have judgment of our court, not only here, but in Itanagar bench also in the, in connection with the Nagaland also, that wherever the application is made, but the compensation must be
Of the
under the-
beneficial one.
Yes. So how are you aggrieved actually?
Well, that I am aggrieved because, my lord, by making an amendment of the 2013 Act, how can 1964 Act, which stood repeal, can be revived? My lord, the moment with effect from 1/1/2014-13, this 64 Act goes, it's to repeal. Yes, first have the constitution for a moment, my lord. Please come to the 7th schedule. Please come to 7th schedule, list 3, my lord, entry 42. Acquisition and requisition of property. Entry 42, list 3. Acquisition and requisition of property.
These three.
Yes, my lord, concurrent list.
Yes.
Acquisition and requisition. So this is a subject, my lord, covered under the concurrent list. Now please come to 254(1). If any provision of a law made by the legislature of a state is repugnant to any provision of law made by the parliament, which parliament is competent to enact, or to any provision of an existing law with respect to one of the matters enumerated in the concurrent list, then subject to such provisions of clause 2, law made by the parliament, whether passed before or after the law made by the legislature of a state, as the case may be, the existing law shall prevail, and law made by this legislature of a state shall, to the extent of repugnancy, be void. So, my lord, the moment on 1/1/2013 Act came into force, the state law lost its efficacy, my lord. So the field has been ceded to the central law. So it's an occupied field. Now state cannot have law. Now, my lord, the state law, it received the assent of the president in 64. I think it was 29th of July, 1964. But with the coming into force of the 2013 Act, that stood repeal. Now, what the state has done, it has not adopted a very ingenious method of colorable exercise of power. What they have done, my lord, they have made an amendment, state amendment of the 2013 Act. Very well. Now, but by doing so, they have inserted Act of 64 in my lord fourth schedule. How can they do it? Yes. The page number 154, my lord. 134. Please come to me, Lord, the impugn amendment of the Assam Act.
137
I'm
Page-
just indicating, my
number?
lord.
Page number?
Page number 134 is the State Act Amendment. 17th of May 2025. Please come to me, Lord, 135. Further to amend right to fair compensation and transparency in land acquisition, rehabilitation and resettlement of 2013. Then the act may be called right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act, Assam Act 2024. Then please come to 137, my lord. In the principal act, after section 105, the following shall be inserted, namely, subject to subsection 2, the provisions of this act shall not apply to acquisition of land under enactment specified in the fifth schedule. The state government, subsection 2, state government may by notification within 1 year from the date of commencement of this act, direct that any of the provisions of this act relating to determination of compensation in accordance with first schedule and rehabilitation and resettlement specified in second and third schedule being beneficial to the affected families shall apply to the cases of land acquisition under the enactment specified in the fifth schedule, or shall apply with such exception or modification that do not reduce the compensation or dilute the provisions of this act relating to compensation, rehabilitation, and resettlement as may be specified in the notification as the case may be, provided that no such notification shall be issued except on the resolution passed by the state legislature. Now please come to 138. This is the most important part. The list of Assam enactment regulating land acquisition in the state of Assam, Assam Land Acquisition and Acquisition Act 64. So, my lord, how by an state amendment of the Central Act, which state is otherwise competent to do, because the subject is in concurrent list, but how an repeal act can be revived, my lord? The end result is in fifth schedule, now Assam Act is included. That means it will not apply. On one hand, they proclaim that it will apply with some modification. Look, this entire exercise is wrong. It's a colorable exercise of power. Where from the state derives the authority, my lord? And my lord will kindly see after 2013, this aspect subject to corruption, my lord, I feel that from 2013 only, the situation changed. Somehow, my lord, it did not, it escaped notice of everybody, my lord. Now, my humble submission is, with passing of 2013 Act effect from 1st of April 2013, Assam Act stood repeal, 64 Act. If it stands repeal, how by as a state amendment of a central act, a repeal act can be revived? Now the notices, and kindly see the notices, my lord. The notices are at section 3, notices are at page 92. Yes. No, my lord, I think state will have to withdraw this. They will have to issue notification under 2013 Act. They have no way out. They cannot adopt this route of rake. My lord, kindly see, even otherwise, 1964 Act was never meant to be invoked when the purpose for which the acquisition is made is permanent. Normally, my lord, if section 3 earlier interpretation of this honorable court was, supposing, my lord, there is a flood. Now flood affected people are to be rehabilitated. Then they will requisition a school property, make them stay there. So it was only for a temporary purpose. So where is the scope of when there is a central act, which is a much better progressive law? And my lord, where are the procedural safeguards which are in the 64 Act, which we find in 2013 Act? There's no concept of notice. There's no concept of any assessment under the 64 Act. Straight away they can invoke, because that was an emergency power given to deal with situations which require urgent thing. But land acquisition is not an urgent thing. Once for all, you will acquire the property. It's a compulsory acquisition. Now please see and look at the page 92, my lord, notice. In exercise of the power conferred on me under section 3(1) of the Assam Land Acquisition Act, under notification so and so, I Sumit Satwan, so and so do hereby requisition under 3(1) of the so and so Act. Why? Why not 13 Act?
You know, from day one, we'll have to.
And my lord, this for Atropolis or something, you have to permanently acquire some land. Why are you requisitioning this? Because you do not have the money to pay. You are putting the citizens in peril.
You obtain possession right away.
And my lord, because by resorting to, my lord, the section 1964 Act, they can straight away take possession. Whereas under 13 Act, they will have to undergo several processes. End of the day, my lord, 300A is violated. Article 14 is violated. And you see, my lord, now under this dispensation, they have two options. They can straight away invoke 2013. They can invoke 1964 Act if this action is to be upheld. Is it not a discrimination? The similar, Lordship knows in that Nagpur Development Authority's case way back in 1973, the Constitution bench said, you cannot adopt two yardsticks because you are acquiring land for public purpose, say school. You can apply one set of rule, and for construction of road, you acquire land, you apply another mode of land. It has to be uniform. Now, what you cannot do directly, they're trying to do indirectly. So, these notices needs to be stayed for the present. Also popular. Well, my humble submission is that the legality part, Lordship will issue notice and all, but this notice needs to be stayed. Otherwise, it will put the petitioner under serious prejudice.
My lord, the issue is a big issue, debatable issue. Lordship, fix the matter for hearing. Reply to that. Need some time. Yes, that's right, that's right. Okay. At this, the notice, at this notice, Lordship.
Yes, my lord. Stay of the notices, my lord.
At this stage, my lord,
Page 31.
Lordship, short date may be what? In the interim
My
permit.
lord, who are the petitioners? I am not, generally, there are so many patadas. Who are the petitioner? My name is at, my lord, serial number, page 105. 94. Pannalal Vansali, 85.
Lordship may fix it on Monday next. If your Lordship, as they prayed for interim leave, Lordship may issue notice on the prayer for interim relief.
Yes.
No, that's why I'm asking your Lordship, short date, Monday only. Ultimately, it will affect, generally it will affect. Notices are issued only on the month of July. Lordship, 1 week time, I think,
Don't take possession. You are restraining you from taking possession. You do any other thing you want. Make assessment, you go ahead with any assessment you want to make out. Because you see,
my lord.
Mr. By calling you with the name of Raj, you forgot your surname.
Bora.
Sorry.
It's okay. Lord.
But I call him Raj Bora.
Can you get us information
Well,
as to whether the compensation amount has been paid to the to any of the petitioners
yes,
at
Yes.
2 o'clock?
today, sir.
Yes, whether payment has been made. You see, the reason is
Mm.
under any requisition act or acquisition act, no, sorry, not requisition, an acquisition act. Possession is taken over only after payment is made.
Yes,
So if you can show that the payment is made, then we don't give an interim order.
Yes.
But if you have not made the payment, then you just can't take over possession.
Lord,
At 2 o'clock,
yes,
get the
yes,
information.
yes.
At 2 o'clock.
Yes.
I'm deeply aware.
So once the payment is made, then Mr. Chaudhary,
No, I have not received.
you'll have to make a
No,
different.
no, my lord,
then.
we haven't received. That I know, my lord.
It's okay. But thanks for the change.
Deeply aware. And even while preparing the case, we also found the subject to be very interesting.
At least we had to open the constitution.
Deeply aware.
And once again, I just can't miss an opportunity of smiling when I can. So,
Right.
no, what you call, no disrespect to anybody in the bar. Okay.
Deeply aware.
Item 8 for motion.
May I please, your Lordship? My lord, the expertise opinion at page 47, my lord.
47. 2021.
Page 47. This is the expertise order, my lord. And my lord, the petitioner was taken into custody on 25/5/2025. Earlier, the son of the petitioner, my lord, filed a habeas corpus, my lord.
You have annexed the order sheet of the tribunal?
Order sheet, my lord, at page, my lord, 34. This is, my lord, type copy, and my lord, the original at page 38.
Con has received the notice, Lordship, page 33.
Notice has been served.
Yes. notice, my lord, at page 31 and report, my lord, at page 33. The son of the petitioner, my lord, received the notice.
Heard Mr. S.A. Ahmed, learned counsel for the petitioner and so on so forth, respondents. Right, finding this repetition on Article 226 of the Constitution of India, the petitioner is saying, page 47, ex parte opinion dated 26/2/2021, passed by so and so and so and so. They were declaring the petitioner to be a foreigner post 25 in 1971. Do you have a copy of the earlier order and passed in the habeas corpus?
My lord, yes, my lord.
Please pass it on.
I have not annexed, my lord.
No, it's okay.
I have. But I'm sorry, my lord, I have only one copy.
No, it's okay. We don't read.
My
It's okay. In view of the inordinate delay in selling the impugned opinion, keeping the issue of maintainability open, issue notice returnable on free date for 4 weeks. And so and so. Extra copies within 2 days. Let the records of the tribunal be called for from the concerned tribunal by issuing notice at the email by notice through requisition through email at the following email address of the learned tribunal. Next, the learned counsel for the petitioner has submitted that in the meanwhile, the petitioner, namely so and so, has been taken into custody on
25/5/2025.
25/5/25. Accordingly, comment is provided that till the next date of listing, the petitioner, namely so and so, shall not be deported out of the country without order of the court. Next, the petitioner shall produce a certified copy of the order before the in charge of holding area, 7th Assam Police Battalion, Saraikala, Kokrajhar, to bring the order to the notice of the said authority. Next, list on so and so. Just before that, you say the prayer for bail shall be considered on receipt of reports.
Item 9.
My lord. The contested case, my lord. Two, my lord, in the Lakhimpur, my lord, FT, my lord, 2 cases were initiated, my lord, and 2 separate order has passed, my lord. Although, my lord, both cases are amalgamated. Lord, I have got an annex, my lord. My birth certificate, my lord, as well as,
So
my lord,
you are challenging the opinion.
opinion, I am a foreigner.
Where is that?
On page 47. This is the first case, my lord. Another letter, another case.
Page number
Page 47.
47.
Well,
No, 47 is the. Where does it start?
we start from, my lord, 39. The relevant portion is मतलब page
It's okay.
44. 43 man.
Right, Mr. A. Kanigar, learned counsel for the petitioner and so and so for the respondents. Opinion at page 39, dated 19/8/2025. Authorized also in case number so district number so it the petition to be a foreigner of 25/3/1971.
मतलब another case is 48 मतलब this is under the journal, same as journal. Both cases are amalgamated मतलब but separate order has been possible. Double point. One man is 282 case number मतलब and another is मतलब 19.
As well as page 48. Opinion dated 19/8/2025, passed by so and so in. so and so. They were declaring the petitioner to be a foreigner post 1973. It is projected that both the cases were heard analogously. Notice returnable in 4 weeks, call for the record, the extra copies will be given. The prayer for bail is opposed by General Stanikos for the FT matters. Considering the projection, 10 days time to take bail of rupees 5,000 in both the proceedings, in connection with both the proceedings before the Superintendent of Police, Border, Lakhimpur. Let's start for police or licit or records. You take bail in both the cases.
Deep knowledge.
Item 10,
Yeah, please, your lordship. My lord, impugn common order, my lord, at page 50, my lord. Ex parte order, my lord. Page 50. In this case also, my lord, earlier the son of the petitioner filed a habeas corpus, my lord. Thereafter, my lord, this.
You have a serial number?
My lord, serial number 1, my lord. First page, page 50. Abdul Ali. That's my lord, opinion dated, my lord. 28/2/2022, my lord.
Please keep a track. We have, I think we have passed more than 50 orders
yes.
in this.
Yes, Doctor.
My lord,
In this
kindly,
case which has only 11.
my lord, the service of notice, my lord, at page 31, my lord. Concurrently, 2 notices were issued, my lord, and the report of the police, my lord, at page, my lord, 33. First notice, my lord. Page 31, my lord, first notice is started from page 31. And report, my lord, at page 33. Thirty-four is the Gaubura report, my lord, Gaubura certificate. And my lord, second notice is start from page 38. And report at page 40, my lord.
You call for the records.
Lordship.
But Mr. S. A. Ahmed, then counsel for the petitioner and Spencer for the respondents.
Opinion at page 50, my lord, 50. Opinion dated 28/02/2022.
Finding this declaration under Article 226 of the Constitution of India, the petitioner has assailed the ex parte common opinion dated 28/2/2022, passed by the learned member, Fairness Tribunal, Jorhat, Assam, in serial number 1, page 50. Thereby holding that the notice was displayed oblique pasted at the conspicuous part of his last place of residence, and accordingly declaring the petitioner to be a foreigner of 1971 stream. Notice returnable on 5/12/2025. Copies within 2 days. Call for the records. The prayer for bail shall be considered on receipt of records. However, if the petitioner, namely Muhammad Abdul Ali, is apprehended,
On 25/5/2020.
already apprehended. Okay.
Yes,
The Learned Counsel for the petitioner submits that the petitioner, namely Abdul Ali, is already apprehended on
5/5/2025.
2025 and is currently lodged at, where is he now?
Soraipula, my lord.
Holding center,
7th.
7th AB Battalion, Chorakla District, Kokrajhar. So accordingly, it is provided that the petitioner, namely so and so, shall not be deported out of the country without order of the court. Next, the petitioner shall cause the production of a certified copy of the order before the in charge of the holding area, 7th AP Battalion, Raipura District, Kokrajhar, to bring the order to the notice of the said authority. List on requisition to email address for the traffic. List on so and so.
5/12. Obligement.
Item 11.
Item number 11 and supplementary. Item number 54, same Milord. And this says I'm praying for a notice. Milord, these are all employees working as a e-staff.
You have noticed.
Yes.
Heard. Mr. K. Chaudhary, Learned Senior Counsel, assisted by Mr. K. Ahmed, Learned Counsel for the appellant, sorry, petitioners.
Finance.
As well as Ms. Arbor Bora, Learned Government Advocate. And Venkatesh Sharma, Learned Counsel, Learned Standing Counsel for Respondent. Four.
I'm for 1 and 3, finance, Vigo,
One and three.
Vigo as 7.
Yes, for 1 and 3. You are for?
1 and 3.
No, you are
Number 4.
responding. Watch it. After representing Mr.
Thank you, sir, my lord.
N.K. Sharma. Then council for respond number 4. The issue of upgradation of the pay structure of the petitioners is the same, is agitated by filing this writ petition under Article 226 of the Constitution of India. Issue notice returnable on, give a date after 4 weeks. 5/12/2025. Extra copies of the writ petition will be served on the council paying for the respondents within 2 days. List on swell, so
Same order in item 54 supplement.
50 same order.
They are system officer, these are system assistants.
54, Lordship, I am appearing for respondent 1 and 2.
In 54, she's for 1 and 2.
Then
You're for?
V Gogoi, respondent number 3.
4. And Mr. Gogoi, oh, sorry, I forgot the name. Mr. B. Gogoi, standing also for finance.
3.
Or 3.
Can you take a or 8 or 9?
8 or 9. Okay, no issue with that.
Instead of fifth, it's okay,
8.
Miller.
Okay.
Lordship, he has come. Finance.
So second matter is agent earlier, Sanjay Finance.
Develop.
Deep level.
Item 12 for motion.
May it please, Lord.
Yes.
The rejection of my miscellaneous application by the deity seeking stay of a section 14 order is under challenge here.
Once a notice under 13(2) is issued, you'll have to go to DRT.
My lord,
After the recent judgment of the Supreme Court,
my lord,
DRT is competent to
my lord, we have approached the DRT under 17. DRT rejected my miscellaneous application. And against that rejection, I have come here. And my stand would be, my lord, that section 18 of the Surface Act doesn't contemplate any appeal against any interlocutory order. That's, my lord, I will try to pursue it, my lord, your lordship.
That's it. That's it. That's that. Security. Yes.
18(1). May I read, your lordship?
Yes.
Any person aggrieved by any order made by the Debt Recovery Tribunal under section 17 may prefer an appeal along with such fees as may be prescribed to the appellate tribunal within 30 days from the date of receipt of the order of the Debt Recovery Tribunal. Now, this any order, I kindly read in the light of the second proviso.
provided further that no appeal shall be entertained unless the borrower has deposited with the appellate tribunal 50% of the amount of the debt due from him as claimed by the secured creditor or determined by the debt recovery tribunal, whichever is less. Now, under the second proviso, my lord, the statutory deposit is a precondition. Without the statutory deposit, my lord, there should be no appeal. Now, what would be that deposit also prescribed by the second proviso? It says 50% of the amount as claimed or determined by the debt recovery tribunal, whichever is less. Now, whichever is less, my lord, has some significance. Now, this expression denotes, my lord, a comparison of two lesser amount, and it refers to lower of the two. So there must be some comparison of two amounts in order to get the amount which is less, whichever is less. Now, there cannot be any determination, final determination, my lord, at the interlocutory stage. Since there is no determination, my lord, there cannot be any comparison between these two elements. Amount claimed by the bank or determined by the DOT. So the intention is very clear, my lord. Intention is to provide an appeal only against a final order, not against an interlocutory order. Secondly, my lord, 17 doesn't contain any specific provisions empowering the DOT to pass any interim order, unlike RDB Act. No specific provision. Now, 17(7), can you read 17(7), man? It says, save as otherwise provided in this act, the debt recovery tribunal shall, as far as may be, disposed of application in accordance with the provision of the recovery of debt due to bank and financial institution. Kindly also read section 37. Section 37 says, the provision of the Surface Act shall be in addition to, not in derogation of, RDB Act. So by virtue of, my lord, 17(7) and section 37, the provision of RDB Act has been read into this Surface Act by incorporation or by reference. Now, kindly see also section 34, the bar of jurisdiction. It says, no civil court shall have any jurisdiction to entertain any suit or proceedings in respect of the matter which a debt recovery tribunal is empowered by under this act. So bar is only in respect of a civil court entertaining a suit in respect of matter which the tribunal has the jurisdiction to entertain. Now, can you see the RDB Act, man? Just for a moment, RDB Act. No, yes. All I'm saying that, my lord, 17(7) and section 37, it says the RDB Act will be read into in SURFACE Act. Now, under the RDB Act, can you see the RDB Act for a moment? Section 19. (19.4.3). (19.4.3), my lord. It says 19.4 says, my lord, 19.4, on receipt of application under subsection 1 or subsection 2, the tribunal shall issue summons with the following direction to the defendant. Can you see 3? To restrain the defendant from dealing with or disposing of such asset or property disclosed under clause C of subsection 3A pending hearing and disposal of the application. So under 4.3 empowers Debt Recovery Tribunal under RDB Act to issue a stay order. There's a specific provision. And also subsection 25. Subsection 25 says, my lord, the tribunal may make such orders and give such directions as may be necessary or expedient to give effect to its order to prevent any abuse of this process or to secure the end of justice. So this 25, my lord, subsection is akin to section 151 of the CPC. Since it's a tribunal, my lord, and it has no inherent jurisdiction, and therefore this power has been specifically provided to pass any orders to secure end of justice. Also read section 22, my lord. (22.1) says, the tribunal and the appellate tribunal shall not be bound by the procedure laid down by Code of Civil Procedure, but shall be guided by the principle of natural justice. That 22 has been interpreted by the Supreme Court. It says tribunal has power which is more elaborate than the civil court and the CPC. Only rather that it should be guided by the principle of natural justice. So this Supreme Court has interpreted, my lord, 925 and section 22.1. In support of the proposition that DAT can issue a stay order which is not be confined to just indicated in subsection 4.3. 4.3 says, what is the interim order that DAT can pass under its 19 application? By interpreting subsection 25, read with 22, my lord, Supreme Court held that it is not confined to this particular specific interim order. It can pass any order for end of justice. So by application of these provisions, my lord, since the provision of DAT has been read into SURFACE Act, the DAT also has a power to issue interim order under section 17. Now, can you also consider the appellate provision under RDB Act? Section 20. Section 20. When section 20 and 21 is in parametry with section 18 of the SURFACE Act. It's an appeal to the appellate tribunal. Save as provided in subsection 2, any person aggrieved by an order made or deemed to have been made by a tribunal under this act may prefer an appeal to the appellate tribunal having jurisdiction in the matter. Any person aggrieved by an order may prefer an appeal to the appellate. And 21, section 21 says about deposit of 50%. So almost identical to section 18. But there are judgment, my lord, of the Supreme Court, where it says that against an interim order passed by the DOT in a section 19 application, judicial review under 227 is maintainable. Yes, I'm getting. What is? In support of my proposition, my lord, the judicial review lies. I'm relying on pre-judgment. I've given it 99-6 SCC 755. Lordship, may kindly first take up 99-4 SCC 710. 99-4 SCC 710. For facts, my lord, may kindly come to para 15. Page 719, my lord, last para, my lord. Last page. Para 15. We may refer in brief to the facts of the case in civil appeal number so and so. ICICI filed an application under section 19 of the Act. Oh. I'm sorry. Lordship, may kindly. The fact is that an application was filed by ICICI under section 19. And ad interim injunction was granted. That was assailed in a 227 application. That's the fact, madam. Granting of injunction, my lord, was put to challenge in his 227 application. Now, para 14, I would like to rely on para 14. Para 14 says, my lord, the High Court also said that on merit as well as para 14, man. Second Mugdiwan, my. Yes, sir. May I read para 14? Yes. High Court says, my lord, there was no bar on the High Court to itself examine the merit of the case in the exercise of its jurisdiction under Article 27 of the Constitution, if the circumstances so require. There is no doubt that the High Court can even interfere with interim orders of the court and tribunal under Article 227 of the Constitution if the order is made without jurisdiction. This observation was made in an SLP against passed by the High Court in an interim order. High Court order was set aside only on merit, not on maintainability. Other case is 99-6 SCC 755. I think this is later to remember. For facts, can you see para 3, madam? That the bank filed a suit under section 19(1) of the Act before tribunal on so-and-so for recovery of monies in the sum of so-and-so from respondent number 1 to 3 and other reliefs. Pending the case, the bank applied on so-and-so seeking temporary injunction, restraining the respondents from taking any monies or sum from the so-and-so. When the advance copy of the IA was sought to be served on the learned counsel for the respondent, the same was refused. Tribunal then passed an interim order of injunction on so-and-so, following terms, madam. Can you see, fourth, the respondent moved the application, moved High Court in an application under Article 226 of the Constitution against that interim order, madam. The High Court, in its order dated so-and-so, held that under 19(6), the tribunal had only limited power to pass interim orders on certain types, but the injunction granted was not of the type enumerated in section 19(6). The High Court therefore set aside the tribunal order. Bank then filed this appeal. that in para 9 and 10, Lordship will find that the Supreme Court interfered with the order of the High Court by interpreting the 20-1. Under 20-1, the power of the tribunal is not limited to pass interim order as enumerated in 1906. It can go beyond that. So it was decided only on merit, not on maintainability. Maintainability was accepted. Section 22 was interpreted in para 9. Now, all I'm trying to show, no, I'm not on the interim order. I'm on maintainability of an application under 227 against an interim order. All I'm saying, there also RDB, there is an alternative forum because section 20 and 21 is in parameter to section 18 of the SURFACE Act. Language is almost identical. 20 of the RDBA says, my lord, that any person aggrieved by an order of the tribunal can prefer an appeal. Same is section 18. Despite that, my lord, 227 was admitted and the Supreme Court didn't find any fault on that against rejection of interim order. Since, my lord, the provision of RDB Act has to be construed in the SURFACE Act, therefore, that same principle will also apply. That's my submission, my lord. That's my submission. In an identical, my lord, order, asked in an earlier essay, distinct essay, my lord, I approached this honorable court. And this honorable court is pleased to stay this order. I have annexed it. That matter is pending adjudication. Page 35, my lord. Page 35. Rejection of section 14 order. Stay against section 14 order, my lord. And that matter is pending adjudication.
May I please, your lordship? Your lordship, my lord is well versed with section 17. Now, section 18, my learned friend has already read the language of section 18 of the SURFACE Act. Now, lordship, the opening word of section 18, may I read again, lordship, for a moment? The parameter of section 17 of the SURFACE Act is to consider whether there is procedural lapses within the ambit of section 17 of the SURFACE Act. Now, section 18, if I may read again, lordship, section 18 for a moment. Then I'll be placing some decisions also. And if any person aggrieved by an order made by the deputy, the word is by any order. The any order, lordship, in my humble submission, in my respectful submission, had the intention of the legislature would have been the final order, that would have been specifically mentioned. The intention of the legislature was not that. Any order includes both final order as well as interlocutory order. That is in my respective submission. Under section 17, now, lordship,
it is not their case that they have not approached this honorable, the DRT under section 17. The learned Debts Recovery Tribunal, while exercising power under section 17, have rejected their SURFACE application. It is not binding on the learned Debts Recovery Tribunal that their application should, interlocutory application should be accepted. The learned Debts Recovery Tribunal, after hearing both the sides, have rejected their application while exercising power under section 17. No, any order in my respectful submission is both interlocutory and final order. Now, Lordship, my learned friend has came to the position submission of provision 2. Provided that no appeal shall be entertained unless the borrower has deposited with the appellate tribunal 50% of the amount of debt due from him as claimed by the there is two versions, your Lordship. One is the amount of debt due. The debt is not defined in the SURFACE Act. We may take help of the Recovery of Debts and Bankruptcy Act. Here, the definition of debt is defined, which the borrower claims from the Lordship. For a moment, the debt is defined in section 2, subsection G in the Recovery of Debts and Bankruptcy Act. And in the SURFACE Act, it is specific that the debt shall means any liability which is claimed as due from any person pooled as investment vehicle as defined in clause 2 of the Securities Contracts Acts by bank or financial institution or by consortium of the banks or financial institution during the course of business activity undertaken by the bank or financial institutions. Lordship, what about the bank or financial institution claims? It comes within the definition of debt. Now, I'm coming back to section 18 again, Lordship. 50% of the amount debt due claimed by the bank, secured creditors, or determined by the Debts Recovery Tribunal, whichever is left. Now, there are two versions. One is claimed by the bank. Another is determined by the DRT. The determination by the DRT has to be under section 19 of the SURFACE Act of the DRT Act. That is a settled law. If the bank files an original application, my learned friend was referring to section 19. Section 19 of the Recovery of Debts and Bankruptcy Act relates to the original application filed by the bank. Now, Lordship, so for the amount as claimed by the secured creditors, the amount claimed by the secured creditors is in the section 13(2) demand notice. That is the amount claimed by the secured creditor. When we come to the version secured creditor, the amount claimed by the secured creditor is in the demand notice under section 13(2) of the SURFACE Act. Why I'm saying, Your Lordship? Let us come to section 13(2) for a moment. When the section 13(2), Lordship, when the borrower who is under liability to the secured creditor under security agreement makes any default in repayment of the secured debt, here again the debt, or any installment in his account in respect of such debt is classified by the secured creditor as non-performing entity. Secured creditor may require the borrower in writing to discharge in full his liabilities to the secured creditor within 16 days. The notice. That is we have given notice on the second. From there, the notice, when we issue notice under section 13(2), we enforce the SARFAESI Act. So the amount claimed by the secured creditor is specific in the demand notice under section 13(2). Now, Lordship, my learned friend was saying that since he has to deposit in amounts, so the section 18 is not applicable. I am relying on the judgment on this point, very specific, Lordship, on this point. AI 2011 Bombay. Supreme Court of No, Vinay Contender. May I take your Lordship to page 5. Page 5 of the judgment. This is a division bench judgment on the same line. Page 5, my lord has got it. Merit. Section 18 provides the right of appeal to a person aggrieved by an order made by the Debts Recovery Tribunal under section 70. The right under section 18 arises in respect of any order made by the Debts Recovery Tribunal. Abate. Under section 17, section refers to any order, and those words are comprehensive enough to include final order as well as interlocutory order. There is no reason or justification for this court to exclude an interlocutory order from the purview of section 1 of section 18. The plain language of section 18 must be interpreted and given effect to a restriction not emphasized cannot be read into section 18. The court cannot rewrite legislation. An order under section 17 of an act undoubtedly includes an order finally disposing of the proceedings on a proceeding and question measures taken by the secured creditor under section 4 of section 13. But equally, the tribunal, while exercising its power in an appeal under section 17, has jurisdiction to pass interlocutory orders which are aid and ancillary to the exercise of a jurisdiction. That tribunal jurisdiction under section 17 encompasses and passing an interlocutory order as well as is no longer res integra, but now a settled judgment by the Honorable Supreme Court in Mardia Chemicals. The second proviso to section 18 postulates no the ratio, your lordship, their settled judgment of the honorable various high courts as well as the honorable apex courts as well as of this honorable court. Just lordship, your lordship will just see the judgment of this honorable court for a moment. I'm just having one copy. Dear lordship, by the division bench of by Lord Justice, Chief Justice, and where a very recent judgment order. Here also, lordship, the question of pre-deposit arose. Against the order of the DRT, appeal was filed in the DRAT. And the DRAT rejected the appeal on the pre-deposit. Then an application was filed before this honorable court. And this was entertained and the matter is sub judice. Now, here in this case, when the matter was entertained, it was entertained based on the decision of the Honorable Apex Court in Sunshine Builders, where the Honorable Apex Court held that So for pre-deposit is concerned, that can be adjudicated again, looking into the facts and circumstances of the case. But appeal is under section 18 is mandatory, irrespective of interlocutory order or final order. And that is what the division bench of this honorable court has also held in this. So in my humble submission, Lordship, in this case is the statutory provision being appealed against the order of the DRT. The appeal should have been filed. This writ application should be dismissed on limine, Lordship. And there is various other judgment of the Honorable Apex Court also in Lordship in Axis Bank's case also, where the Honorable Apex Court has held, even in an interlocutory application, if pre-deposit is made, and if the SURFACE application they succeeds, that amount will be refunded. That is in the judgment of Axis Bank's case in 2016 Supreme Court cases. The Honorable Supreme Court has held went to that extent. You make pre-deposit in interlocutory application. Yes, I'm giving. This is Lordship in Narayan Ghosh versus UCO Bank. That is also regarding pre-deposit mandatory by the Honorable Apex Court. And this is in respect of Axis Bank's Lordship, with the Honorable Supreme Court in respect of interlocutory order, where the Honorable Apex Court has held that if the SURFACE application succeeds, then the amount deposited can be refunded back. The bank cannot give it, but in an interlocutory application, the amount has to be. That is in paragraph 2.
Mr. M. Nath, then counsel for the petitioner. As well as Mr. K.K. Nandil and Mr. N. Nath, as well as K.K. Nandil and counsel appearing for the respondent number 1. And for the respondents. Next paragraph. it is not in dispute that the petitioner, along with his father, namely Shams, SHAMS, next word Uddin, next word Chaudhary, and brother, comma, namely, comma, Gyas Uddin Chaudhary, comma, jointly applied for a home loan of rupees 71 lakh in the year 1920, in the year 2022. Full stop. Pursuant to the loan availed, comma, an equitable mortgage which created in respect of the security assets which is more fully described in paragraph 3 of this writ petition. Full stop. Having availed the loan, comma, the petitioner now contends that the equitable mortgage was created outside the notified area under section 58 within bracket F of the Transfer of Property Act. And accordingly, comma, creation of mortgage is claimed to be illegal. Full stop. It is, next para, it is also not in dispute that the respondent number 2 had issued a notice to the petitioner under section 13 within bracket 2 of the securitization and reconstruction of financial assets and enforcement of Security Interest Act, 2002 within bracket SARFAESI Act for short, SARFAESI, SARFAESI Act for short, read with Rule 8 of the Security Interest within bracket enforcement bracket post rules, 2002, dated 12/11/2024, calling upon the petitioner to discharge and repay the outstanding loan amount with interest within 60 days from the date of receipt of notice. Full stop. Thereafter, on 6/2/2025, constructive possession of the security assets was taken over by the respondent number 2. Full stop. Thereafter, the respondent number 2 applied before the district magistrate, Hailakandi, on 28/3/2025 to provide assistance for taking over possession of the security assets. Accordingly, by an order dated 9/5/2025, the additional district magistrate, Hailakandi, entrusted the concerned circle officer, Algapur, ALGAPU, and executive magistrate, Hailakandi, provide the necessary assistance to the respondent number 2 for securing the possession of the secured assets. Full stop. Accordingly, the respondent number 2 by a letter dated 23/7/2025 put the petitioner and the other borrowers to notice for taking over possession in terms, which is more fully mentioned in the said notice. Full stop. Agree by the steps so taken, the petitioner had approached the Debts Recovery Tribunal, Guwahati, by filing a SARFAESI application SARFAESI application is under which provision?
Section 17.
17.
Under section 17 of the SARFAESI Act. Full stop. The same was registered as S full stop, A full stop, number 116 of 2025. Full stop. The petitioner had also filed an interlocutory application which was registered as IA number 614 of 2025. With a prayer to stay the operation of the vacation notice dated 23/7/2025. Pursuant to the order dated 9/5/2025, passed by the additional district magistrate, Hailakandi. Next. The learned tribunal, by an order dated 2/9/2025, had dismissed the said interlocutory application by holding that the petitioner has failed to make out any prima facie case in his favor, and that balance of convenience was also not in his favor. And the SARFAESI application was listed for hearing. Next. The learned counsel for the petitioner has submitted that the various provisions of the SARFAESI Act and rules framed thereunder read with the Recovery of Debts and Bankruptcy Act, 1993, and rules framed thereunder vests jurisdiction upon the Debts Recovery Tribunal to pass an interlocutory order in support of the contention that the tribunals have the power to pass interlocutory orders. The learned counsel for the petitioner has placed reliance on the following three cases. These are three, 1 to 3 are not. Next para. The learned counsel for the petitioner has also submitted that notwithstanding that the provision for an appeal is prescribed under section 18 of the SOFICI Act, but for filing an appeal, the petitioner would have to apply, have to make a pre-deposit. Full stop. It is submitted that as the debts due has not been determined under the Recovery of Debts and Bankruptcy Act of 1993, the claim would be based only on the basis of the notice that the dues declared in the notice issued under section 13 within bracket 2 of the SOFICI Act. Stop. However, under second proviso to section 18 of the Securitization Act, the petitioner has the liberty of paying the reduced amount of fees on the two on the lower of the two determination of the debts. Correct?
No, my lord, I'm saying that there is no appeal provided against an interlocutory order
No,
because
that's
of.
okay, but this proposition which you had argued, the first submission of yours
Yes.
was that there are two dues. That recording of your submission is correct or incorrect?
My lord, my submission was, my lord, that in view of second proviso, whichever less is to be provided.
That's what I've dictated. Is it
but-
correct or not?
Yes, yes, correct. ma'am. But there is no occasion to correct it in an interlocutory stage.
Stop. However, full stop. However, it is submitted that the appeal to the appellate tribunal would only lie against the final determination and not against the determination made in the interlocutory application. Full stop. It is next para, it is further submitted that in a similar application challenging the action taken under section 14 of the SOFICI Act, this court had entertained a writ petition in the matter of Messrs. Moon Enterprise and another versus State Bank of India and another, page 34. WPC 449 of 2024. And in the said proceedings, this court by an order dated 2/2/2024 issued notice and the order dated 31/8/2023 passed by the district magistrate concerned was suspended. It is submitted that the said writ petition is pending for disposal before this court. Next, the grounds on which the impugned order has been assailed are contained in subparagraph 1 to 17 Roman 1 to 17 of paragraph 2 of this writ petition which are not reproduced herein for the sake of brevity. It would suffice to mention that the endeavor of the petitioner is to demonstrate that the manner in which assistance under section 14 of the Sufficy Act was sought for and granted by the additional district magistrate are not in accordance with law and liable to be interfered with. Next part. Per contract, comma. The learned counsel for the respondents has submitted that it is too well settled proposition of law that as section 18(1) of the Sufficy Act contemplates filing of an appeal and against any order, any is inverted comma, there would be no bar for the petitioner to file an appeal to stop. Moreover, comma, it is submitted that the pre-deposit is subject to such orders that may be passed in an interlocutory application accompanying the appeal before the appellate tribunal. And in this regard, he places reliance on the following two cases. Three cases. Here are read R1, 2, and 3. Next paragraph is further submitted that in the proceedings of, just find out the case number, WPC 4153 of 2025, as regards the quantum of deposit, this court had issued a notice and in the interim it was provided that the to the effect that the Debt Recovery Tribunal shall not dismiss the appeal as infructuous for not having deposited 35% of the recoverable debt amount. Next panel. At the outset, having appreciated the materials available on record and the cases cited at the bar, there is no dispute that the provision of section 18 within bracket 1, sorry, not 18, is 18 provision 1 of the Sufficy Act, the mandate of law is that any person aggrieved by aggrieved inverted commas by any order bracket closed made by the Debt Recovery Tribunal may prefer an appeal. Full stop. The same is, the said provision is in relation to section 17 of the Sufficy Act. Full stop. The next part, the requirement of a pre-deposit is prescribed under second proviso to section 18 within bracket 1 of the Sufficy Act, and the third proviso to subsection 1 of section 18 of the Sufficy Act also provides power to the appellate tribunal to reduce the amount to an extent which is permissible thereunder. Next panel. Therefore, under the facts and circumstances of the present case, when it is not in dispute that the petitioner, along with two other borrowers, had taken a loan, housing loan, and that the amount due has not been refunded or repaid to the respondents. As a rule of prudence, this court would not examine the legality of the order dated 2/9/2025 passed by the Debt Recovery Tribunal, as the provisions of the Sufficy Act provides for an alternative and efficacious remedy by way of an appeal before the Debt Recovery Appellate Tribunal. Next panel. Okay, we are short of time. We'll resume after lunch. Not silly much.
My lord. Please worship, my lord. Item 33. It was a matter, it was heard nearly 1 year, 6 months back by my Lord Justice Pathak. But judgment was not delivered, this transfer matter. My father is in a critical condition. So there is a liberty was given that he may file review petition, and we have filed, but no judgment is yet delivered since last 2 years. It may kindly be listed tomorrow.
You have two options in a lighter note. Two options. Number one, we follow the principles of wall have ears. So if you permit that, then we can dispose it off. But if second option is only to argue the matter, so we'll have to
No.
fix a date.
My prayer is this, either upgraded or it will be listed tomorrow, my lord.
I don't know, we'll try a bit. You want an upgradation, we'll do it. Just wait for some time.
All right.
So 3 or 4 matters have been upgraded.
I understand lordship in the midst of an order, my lord.
Yes, wait for the other side in your case. Mr. Vora? No, it's okay, you got the information? Everything's been released?
My lord, yeah, the lordship may be pleased to peruse the instruction. Yeah, my lord, the award has already been published. And the notices under section 7 of the 64 Act has also been issued. Now, in that instruction, lordship will find, my lord, that they have been asked to submit their bank details and indemnity bond to receive the money, which they are not doing. And the second page is the award statement. So everything is complete.
No, this one.
But since money has not been paid, that there has to be restraint for next 7
Yes.
days. You can't take position.
No, my lord.
Even without making payment, you can't take position otherwise also.
So here is a case where the emergency clause is not invoked. We have gone through my lord, the regular procedure as enunciated in the 1964 Act.
When a challenge is made, what to do?
No, select-
When a
there-
constitutional
therefore,
challenge is
lord-
made.
Yes, I must place these two orders before this court, my lord. Similar issues have also been raised in 2 other writ petitions, challenging the virus of the 1964 Act as well as the amendments made thereof, my lord. Now there, this honorable court, my lord, the division bench of this honorable court has not granted any stay, and the affidavits are being exchanged. These are the orders, my lord.
Just keep copies thereof to Mr. Chaudhary.
Of course.
So, Mr. Chaudhary, give us 10 minutes time. I complete the dictation and take it up.
Yes,
Mr. Chaudhary,
yes, my lord.
10 minutes time. we'll give complete the dictation. Next, brother. The next, brother, the Debt Recovery Tribunal, Appellate Tribunal, in view of section 18 of the Sufficy Act, has the competence to not entertain an appeal unless a deposit is made as per the proviso thereto. And on the other hand, it also has competence to give reasons and to reduce the pre-deposit to an extent as provided under the third proviso to subsection 1 of section 18 of the SURFACE Act. Next paragraph. The other reason to exercise self-restraint in exercising power under Article 226 of the Constitution of India is that the district magistrate and the additional district magistrate are vested with power under section 14 of the SURFACE Act to assist the secured creditor in take possession of the secured assets. So there is no material on record to show that on receipt of notice under section 13 within bracket 2 of the SURFACE Act, the petitioner has made repayment of the financial assistance upon receipt of notice. And therefore, it was incumbent on part of the additional district magistrate, to give the required assistance as provided for under section 14 of the SURFACE Act. Next paragraph. In this regard, it is projected in this petition that there were certain procedural irregularities in passing of the order by the additional district magistrate. So if that be so, even in that situation, it is for the Debts Recovery Tribunal as well as the Debts Recovery Appellate Tribunal to examine the application made by the respondent number 2 under section 14 of the SURFACE Act, as they are the prescribed authorities to entertain the SURFACE application as well as the appeal against the orders passed in a SURFACE application. And therefore, any adjudication by, any determination by this court regarding the disputed question of fact would have the tendency to prejudice one of the two sides. Next paragraph. The statutory law requiring a pre-deposit to be accompanied, to accompany the appeal has not been held to be unconstitutional by any court of law. Therefore, merely because the statute requires a pre-deposit to entertain an appeal would not be a sufficient ground for this court to examine the legality of the order dated 2/9/2025 passed by the Debt Recovery Tribunal. And to substitute its wisdom on the jurisdiction vested with the Debt Recovery Appellate Tribunal. Accordingly, the cases cited by the learned counsel for the petitioner not have the petitioner in any manner as those citations are not authority on the point that despite appellate jurisdiction being available from a writ petition should be entertained against every order that is passed in a surface application by the Debt Recovery Tribunal. Full stop. Next para. As per the ratio laid down by the Supreme Court of India in the case of take that citation from them, Vikartan Das. The contours of the High Court in exercising, in entertaining challenge to the orders passed by the tribunals is well defined. Unless, therefore, unless the order is expressly illegal and vitiated by non-consideration of materials available on record or consideration of materials which are extraneous to the records, are found to vitiate the order, the High Court in exercise of jurisdiction and Article 26 and 27 of the Constitution of India have to, in this case, has to exercise self-restraint. Next, is certainly, this petition fails and is stage without interference, without issuance of notice on the respondents. Next paragraph, nothing contained in this order shall prejudice the petitioner in the event an appeal before the statutory authority is filed. Parties are left to bear their own cost.
Right.
My lord, my learned friend, Mr. Borpujari has referred to an order. That is an order of 21st of April 2025. In any case, the other case, Taini Deka. In Taini Deka, my lord, virus of 64 Act was not challenged. And that is why it was moved before the learned single judge. Now, my lord, Lordship will kindly give me 2 minutes time. Please have this Act of 2013, my lord. My lord, here is the perspective which we are, my lord, placing forward is totally different. What we are saying is, you have invoked concurrent powers under Article 40, entry 42 of list 3 to amend the Act of 13. That means a state amendment has been brought in, whereby you are adding something to the 5th schedule to add something to the Act of 1964, which already stands repealed. Now, question is, you have obtained presidential action in respect of what? In respect of Assam Act, Assam Amendment. But you have not brought any presidential action to save the 64 Act, which stood repealed. So therefore, this notice is per se without any authority. It is void ab initio. Yes. Miller, I'll explain it very clearly, Miller. The 1964 Act, when it was promulgated, it obtained presidential action on 29/7/1964. It continued, my lord. And if we look at the preponderance of the judicial view of this honorable court in respect of 64 Act, it was always said that this power is only for temporary purpose. In fact, my lord, earlier there were 3 legislations, how to give relief to the people who are affected by flood, etc. Those 3 acts were amended and these consolidated, and this act was amended and which received the assent of the president. This is basically under section 3, without any inquiry as is provided under the then 1894 Act, one can resort to requisition, without ascertaining whether it is for public purpose, etc., etc. Then under section 6 of 1964 Act, then they can also, following requisition, they can also acquire. Supposing the purpose for which the land is requisitioned is served, then they can release the land under section 8. That is the scheme of Act of 1964. Simultaneously, my lord, the Central Act of 1894 was holding the field, which contained the subject on land acquisition. Therefore, since there was a presidential accent, so Act stood, valid. It continued. But after 2013 Act came into being with effect from 1st of April of 2013, naturally by virtue of Article 254(1), the Act of 1964 was repealed impliedly. Now, my lord, let us see the scheme of the 2013 Act. Where are these provisions in the 64 Act? My lord, will first come to section 4, my lord, of the 13 Act. Just I'm giving a bird's eye view of the Act. For preparation of social impact assessment study. Then if your lordship would kindly come to section 5, public hearing for social impact assessment. Then, my lord, section 6, publication of social impact assessment study. Section 7, appraisal of social impact assessment report by expert group. Then, my lord, under section 8, examination of proposals for land acquisition and social impact assessment report by the government. And let's see the procedural safeguards which has been given in the Act. These are none is present in the Act of 64. Then eventually, my lord, there is a power of exemption under section 9, where land is proposed to be acquired involving urgency provision under section 40. Appropriate government may exempt undertaking of social impact assessment study. Might as well also refer to section 40, my lord, because this power is also very, very circumscribed. if your lordships would kindly come to section 40. It can be done, please come to my lord subsection 2, when this special power can be invoked. Power of the appropriate government shall under subsection 1 shall be restricted to minimum area required for defense of India or national security or for any emergencies arising out of natural calamities or any other emergency with approval of parliament. Section 40, subsection 2, Miller. Yes. The power of appropriate government under subsection 1 shall be restricted to the minimum area required for defense of India or national security or for any emergency arising out of natural calamities or any other emergency with the approval of the parliament. Now, most importantly, my lord, please come to section 38. When can possession be taken? $38 million. The collector shall take possession of land after ensuring that full payment of compensation as well as rehabilitation and resettlement entitlements are paid or tendered to the entitled persons within a period of 3 months for compensation and a period of 6 months for monetary part of the rehabilitation and resettlement entitlements listed in second schedule commencing from the date of the award under section 30. Provided that the components of rehabilitation and resettlement packages in the second and third schedule that relate to infrastructural entitlement shall be provided within a period of 18 months from the date of the award. Further provided that in case of acquisition of land for irrigation or hydel project being public purpose, the rehabilitation and resettlement shall be completed 6 months prior to the subsurgence of the lands acquired. Collector shall be responsible, etc., etc. Now, what is the public purpose for which the present land is acquired? We do not know expressly, my lord. Now, I'll draw your lordship's kind attention to 2-3 more provisions. Please come to section 105, my lord. Section 105. Subject to subsection 3, the provision of this act shall not apply to enactments relating to land acquisition specified in 4th schedule. Now, my lord, by the state amendment, Assam Act has been brought under this 4th schedule, so as to deprive us from all these benefits. Now, 3. Central government shall by notification within 1 year from the date of commencement of this act direct that any of the provisions of this act relating to determination of compensation in accordance with 1st schedule and rehabilitation and resettlement specified in the 2nd and 3rd schedule being beneficial to the affected families shall apply to the cases of land acquisition and the enactments specified in the 4th schedule or shall apply with such exemption or modification that do not reduce compensation or dilute the provisions of this act relating to compensation or rehabilitation and resettlement as may be specified in the notification as the case may be. Therefore, the idea is, my lord, the benefits should percolate to the landowners. Now, please come to 106. Central government may by notification amend or alter the schedule to this act without in any way reducing compensation or diluting the provisions of this act relating to compensation or rehabilitation and settlement. So, my lord, acquisition is not the only thing they are to do. They are to do rehabilitation and resettlement. Does the Act of 64 provide any such provision? Therefore, the act is repugnant. Then 107. Power of the state legislature to enact any law more beneficial to the affected families. Now, this is where, my lord, the power of the state government needs to be appreciated. Nothing in this act shall prevent any state from enacting any law to enhance or add to the entitlements enumerated under this act which confers higher compensation than payable under this act, or make provision for rehabilitation and resettlement, which is more beneficial than provided under this act. Let my learned friends satisfy your lordships today. It's not a question of argument, sorry, affidavit. It's a question of argument, my lord. Now, what is the benefit which is sought to be given by this amendment, which is over and above we are entitled to get under in the 2013 Act, which is the only power given to the state government? On the contrary, my lord, Act of 1964, under which the notice has been issued, it does not include any procedural safeguard. Even the Section 6 notice which has been issued, that also do not specify anything.
Take possession under Section 4 immediately.
And the possession was taken under Section 4 without having due regard. Then kindly see 108, my lord. Option to affected families to avail better compensation and rehabilitation and settlement. Hmm. '64 Act we have annexed, my lord. We have annexed in the petition. Page 104. And let's see what is the drastic power under Section 3. Page 105, Section 3. If in the opinion of the state government or any other person authorized in this behalf by the state government, it is necessary so to do for maintaining supplies and services essential to the life of the community, or for providing proper facilities for accommodation, transport, communication, irrigation, flood control, and anti-erosion measures, including embankment and drainage, or for providing land individually or in group to landless, flood-affected, or displaced persons, or to a society registered under the Sand Cooperative Societies Act, or a company incorporated under Companies Act of 56, or a company incorporated under the company formed for the benefit and rehabilitation of landless, flood-affected, or displaced people, or to provide land for purpose of construction of border fencing and allied work. This was added, my lord, post Assam Accord. And check the post connected with therewith, along with Bangladesh border. State government or the persons authorized as the case may be, by ordering, writing, acquisition any land, and may make such further order as appears to him to be necessary expedient connection with. So, my lord, the very reading of the statute clearly reveals that the purpose for which the power has been given under Section 3 is not available in the instant case. Somebody wants to make a township in, my lord, near the airport. That is not a public purpose. I'm sorry, my lord, it's not a public purpose. And kindly come to Section 4, my lord.
106.
Power to take possession of requisition land. Where any land has been requisitioned under Section 3, state government or the person authorized in this behalf by the state government may by order in writing direct the owner or tenant or any other person who may be in possession of the land, whether at the time of requisition or at time thereof, before the land, whether at the time of requisition or any time thereafter, before land is released from requisition, to surrender or deliver possession. Well, is it not repugnant to the Act of 2013, which says before taking possession, everything must be over and you must pay compensation? So how this statute can stand in the eye of law? And my learned friend says similar matters were moved. And this amendment was carried out on 17th of May to 2025, and those orders were passed earlier. And in one of the petition before the learned single judge, the specific case of the respondent was that virus of the 64 Act is not under challenge. That is not the position here. We have challenged the virus of the Act. So therefore, my lord, this is a process which lordships will not permit them, my lord, because this is absolutely without any authority of law. Therefore, in my humble submission, my lord, let state file their affidavit expeditiously. Lordship will fix the matter in first week of December. And in the meantime, my lord, my possession should not be disturbed. That is my expectation.
If I may place two more orders, my lord. Now, two writ petitions are pending before the division bench of this honorable court, wherein, my lord, the acquisition proceeding pertaining to establishment of AIMS at North Guwahati, All India Institute of Medical Sciences, have been put to challenge. During the proceedings, my lord, this amendment has come. Now, the state has been asked to file an additional affidavit bringing on record, my lord, the amendment, which is a part of the present writ petition. There also, my lord, the virus of the 1964 Act has been put to challenge. This honorable court has not granted any interim protection, my lord, to the writ petitioners in those two writ petitions. My lord, wherein, my lord, the acquisition proceedings have not been stalled. That is, yes, my lord, 5624, and one is, my lord, 5626.
24.
24, sir. 24.
The
24.
amendment is of 25.
So therefore, I have barely submitted before this honorable court right now that during the proceedings of these two writ petitions, which are pending before this honorable court, this amendment came into being. And therefore, yes. My lord. And my lord, 5626, my lord. There I have submitted order dated 23/5/2025.
First order which was.
My lord.
5624 we are having.
Yes.
What is the other one? We are not having that.
5626. I'm having one more copy, lordship. May kindly peruse this, my lord. 5626. Lordship, maybe please, my lord, I'm sorry, my lord, here I am again supplying, my lord, the orders in chronological order, my lord, in those two writ petitions. Lordships may kindly peruse it, my lord. Lordships may kindly peruse it, my lord. Lordship, may be pleased to come to page 3. Page 3 of that bunch, my lord. So virus has been challenged and no stay. Now affidavits have been exchanged, my lord, and one additional affidavit pertaining, my lord, to the amendment, my lord, is also there. And these two writ petitions are fixed, my lord, on 27th of this month. If lordship may be pleased to see the last page of the bunch of documents, my lord. The last page. 27th. Similar situation, my lord. Similar situation, this coordinate bench has not granted any stay. Pleadings are almost over, my lord, and the matter is at the final stage. So under that circumstances, I pray, my lord, let notices be issued here, my lord, and let this matter be also tagged with those two writ petitions. My lord, that would be my first plague of prayer. The second will be, my lord, here if lordship sees, my lord, the instructions that we have received, my lord, if for a moment, my lord, lordship peruses the instructions. My lord, this instruction 2 sets I have given, my lord, just some time ago. That is dated, my lord, today. If I may hand it over. Oh, therefore, my lord, those. Yes, this one. Paise. If lordship may be pleased to peruse these instructions. My lord, the acquisition is already complete. Award has already been passed. And the award statement lordship will find at the second page. Now, under the scheme of the 1964 Act, once the award is passed and once, my lord, because award and the notification under section 6 are simultaneous. There has to be a gazette notification for section 6. So the section 6 is the final stage. It is completely acquired and the land vests in the government under the scheme of section 6. Now, section 6 notification has been published and it is also a part of this writ petition, my lord. That is a part of the writ petition, my lord. That lordship will find at, my lord, the page 96. 96 is the type copy, my lord. 96, 97 and 98, my lord, is the true copy. And in pursuance of, my lord, section 6 notification under form D, which appears there in the writ petition at page 96, the award has also been passed. Now, pursuant to section 6, an exercise has to be, my lord, taken up by the collector under the provisions of section 7. Now, section 7 notices has also been issued. Section 7 of the 1964 Act says, my lord, the notice to person interested. This is a notice asking them you come and you take the compensation. With regard to claims and whatever may be, my lord, arising out of compensation. They may have a claim, my lord, that the compensation is not adequate. They want enhancement of the compensation. Then it will be a different scheme under the act together if they make a reference, my lord, for enhancement of the compensation to the reference code. That will be a call out, my lord, of the acquisition proceeding, culminating into passing of the award. Now, once the award is passed, my lord, the acquisition proceeding culminates. And the award statement is available before my lord at the, my lord, 2 pages of the instructions which I have just now placed. The lordship has seen the award statement. And it has been received.
Right.
The proceeding culminates, my lord, so far as, my lord, the compensation is concerned. No, therefore, my lord, why I am submitting, because culmination in terms of, my lord, compensation, determining the compensation. Award is only, my lord, related to compensation. So therefore, before passing the award, the 1964 Act itself provides under section 4. Once the requisition, my lord, it is requisition, possession, acquisition, the 3-tier, my lord, land acquisition scheme enunciated under the 1964 Act. Under section 3, I publish a notice that this land is required. I hereby requisition it. So it is on paper. Thereafter, under section 4, I can enter into possession, my lord. My lord. My lord. If for a moment, my lord, yes. Yes. No, my lord, now under the scheme, because we have a, my lord, right to fair compensation 2015 rules for the state of Assam, whereby we are giving compensation as, my lord, within the parameters of 2013 Act. Why we are doing it so, my lord? Because 1964 Act, my lord, the procedure is not that cumbersome. It is requisition, possession, acquisition. But we are paying the compensation as envisaged in 2013 Act. Meaning thereby, my lord, if under the 64 Act, I am to get 100 rupees, and if under the 2013 Act, the same is, my lord, quantified at 200 rupees, the person concerned will get 200 rupees. He will not be deprived. Only to the extent, my lord, of rehabilitation and resettlement, my lord, this act is somewhat silent. Only to the extent of rehabilitation and resettlement. Nothing more, nothing less.
Public hearing.
And few orders, my lord.
নাগপুৰ ডেভেলপমেণ্ট অথৰিটিটো দেখাই দিওঁ কপি আছে নে
Lordship may be pleased to see.
তারপর দিচ্ছে দিলাম বেনিফিট দিব কিন্তু খাতি করতে হবে Just to buttress my point, can I place that constitution bench decision, my lord, which will clarify everything, my lord? One paragraph from that judgment, Jana. Oh, yes. I think he has completed. That's why I spoke. Okay. Oh, I'm sorry, my lord. I'm sorry. My lord. No, it's okay. No, I thought he took his seat, so I thought he concluded.
Now that is coming down, that the good practices we had
Right.
is coming down. And therefore the respect of one side to the other side, that is also resultantly coming down. I'm just reminding myself of that.
In fact, my lord, once AK Sen came to our High Court, he was arguing one matter. Knoll Building Court number 2. He wanted to cite a judgment. That's a towering personality. It took the leave of the court to place the judge. I thought this is the extent of humility they exercise. I was shocked, my lord. We feel that to place a judgment is my right. Yes, yes.
If I may place one more communication, my lord. I apologize, my lord. I had only one copy, my lord. That is, my lord, after coming into promulgation of the 2013 Act. This was a circular issued by the state, wherein it has been stated, my lord, lordship will find it at the second paragraph. Well, in cases where acquisition is done under the 1964 Act, all the protections and privileges that are granted under the 2013 Act, namely, my lord, rehabilitation, resettlement, and the like, will also be provided, my lord, to the affected persons. So there is no denying to those facts, my lord. Because, my lord, only because of the fact, because 2013 Act, if we follow it in letter and spirit, my lord, that is a cumbersome procedure. Only to, my lord, overcome that 1964 Act. No, my lord, this is, no, I am making a submission. Why this act is, my lord, used, my lord, put to effect, my lord, put to force in the present case itself, my lord. Let us take our case, my lord. Now here, my lord, the award has already been published. This is not a part of the act. No, 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 no. That is one aspect of the matter, definitely, my lord. But here, my lord. Yes, yes, yes. This is prior, my lord. This is in the year 2015. Here. So all these things are there, but my lord, at this stage, my lord, I can only submit, my lord, that there are two similar writ petitions pending before this honorable court, wherein, my lord, no interim has been granted, and those are fixed on 27th of, my lord, this month. Then, my lord, lordship will kindly see, my lord, I have placed few judgments, my lord, emerging from Tarini Deka. Lord, I have placed 4 copies, my lord, of 4 judgments. First is, my lord, Tarini Deka, that is 3989. There, what had happened there, my lord? 3989, my lord, of 2022. WPC 3989, 2022, Tarini Deka. my lord, at North Guwahati, in the area of Hingimari, my lord, the NRL Numaligarh Refinery Limited proposed to set up a petroleum storage terminal. Now, that was done by following, my lord, the part and parcels of land which will be required for setting up that terminal were acquired under, my lord, that applying the 1964 Act. There it was put to challenge, and all these grounds of repugnancy and otherwise, and my lord, the availability of a central statute that the proceedings are hit by the provisions of Article 254, so on and so forth, where, my lord, very, my lord, forcefully argued by the petitioner side before this honorable court. Now, honorable single bench has negated their, my lord, argument, their reasoning. And, my lord, ultimately the writ petition came to be dismissed with a, my lord, consequence that the 1964 Act still holds good and it holds much water. It was put to challenge, my lord, in a writ appeal. Lordship will kindly see the writ appeal. Thereafter, I have given it before this honorable court, division bench. It was again negated, upholding the sanctity and edifice of the 1964 Act. It was put to the apex court, my lord, taken to the apex court by the petitioners. Apex court also negated their reasoning, their argument, meaning thereby, my lord, that the sanctity and edifice of the 1964 Act still holds good. And then, my lord, of course, one judgment, that is, my lord, All Assam Tennis Association, which lordship was pleased to deliver, my lord, that also I have, my lord, submitted. There, my lord, part and parcels of land were sought to be acquired, my lord, which were hold up, my lord, used and were under occupation of this, my lord, All Assam Tennis Association. And they had challenged the acquisition proceedings, similar acquisition proceedings, like the present writ petitioners, my lord. Lordship was pleased to, my lord, negate their reasoning, and the writ petition came to be dismissed. They have filed a writ appeal before the honorable division bench. Till today, my lord, that writ appeal has not been moved properly. Every time the writ appeal, my lord, is listed, the appellants seek time, and this is how, my lord, it is going on. So lordship's judgment in All Assam Tennis Association still holds good, my lord. It is the law. So under these circumstances, my lord, lordship, of course, would be pleased to issue notice. We will come up with the affidavits. But granting the petitioners an interim protection at this stage, my lord, in my respectful submission, my lord, would imbalance the equities, my lord. Because since, my lord, rule has been challenged, the provisions of the statute has been challenged, we have to come up with a comprehensive affidavit, my lord, that we are duty bound, my lord. But so far as the interim protection is concerned, my lord, I am resisting the petitioner's prayer only to that extent, my lord. So this is my humble submission.
My lord, I'm sure the perspective which we have placed before lordships, it was not done. In Tarini Deka, it's a case where virus of 64 Act was not challenged. If it would have been challenged, it could not have been laid before the learned single judge. It would have come before DB. So Tarini Deka, my lord, cannot come in the way. Now, my lord, because now, my lord, this amendment has come up on 17th of May 25. Let my learned friends show an order of the division bench after 17/5/25. Because this state amendment is of 17/5/25. My lord, let us go to the fundamentals. Nobody is the owner of any land. It is the state who is the owner of the land. We are only a lessee. For 30 years lease, we get the land. Now, my lord, therefore, by applying the principle of eminent domain, state can take land. But there is a constitutional prohibition in the form of Article 300 capital A that it can be done by an authority of law. What is authority of law? A statute. Now, which is that statute? 2013 Act. 64 has lost its efficacy. If somebody doesn't make this, when the matter in Tarini Deka went to Supreme Court, I don't think this argument was there. Tarini Deka's case must have been that land has been requisitioned under public purpose for Indian Oil Corporation. That was sought to be challenged. Now, what we are saying is, kindly see, today's situation has arisen where state
according to their whims, they can apply either 2013 Act or they can apply 1964 Act. There's no dispute. Now please have this Nagpur Development Authority's case. This is the Constitution Bench judgment way back in 1973. My lord, this judgment is 1973, 1 SCC, page 500. Please come to para 29.
1973, 1 SCC 500. 79. 1 SCC 500. 79.
Now, my lord, sorry, please come to page para 28 at page 506. It would not be, has a lordship got it, my lord? Page 506, para 28. It would not be disputed that different principles of compensation cannot be formulated for lands acquired on the basis that owner is an old or young, healthy or ill, tall or short, or whether owner has inherited the property or built it with his own effort, or whether owner is a politician or an advocate. Why this sort of classification is not sustainable? Because object being to compulsorily acquire for public purpose, the object is equally achieved, whereafter the land belongs to one type of owner or another type. Can classification be made on the basis of the public purpose for the purpose of compensation for which the land is acquired? In other words, can legislature lay down different principles of compensation for lands acquired, say, for a hospital or a school or a government building? Can legislature say that for hospital land it will be acquired at the rate of 15% of the market value, for school at the rate of 60% of the value, and for government building at the rate of 70% of the market value? All the three objects are public purpose as far as the owner is concerned, and it does not matter to him whether it is one of public purpose or otherwise. Article 14 confers an individual right, and in order to justify a classification, there should be something which justifies a different treatment to this individual right. It seems to us that ordinarily a classification based on public purpose is not permissible under Article 14 for the purpose of determining compensation. The position is different when owner of the land himself is recipient of the benefit from improvement scheme, and benefit to him is taken into consideration in fixing compensation. Can classification be made on the basis of authority acquiring the land? In other words, can different principles of compensation be laid if the land is acquired by or for any improvement trust or municipal corporation or government? It seems to us the answer is in the negative, because as far as owner is concerned, it does not matter to him whether the land is acquired by one authority or other. Now this is important 30. It is equally immaterial whether it is Acquisition Act or another acquisition act under which the land is acquired. If the existence of the two acts could enable the state to give one owner different treatment from another equally situated, the owner who is discriminated against can claim protection of Article 14. I am on this, Miller. Now today's situation is they can invoke 64 Act, though 64 Act is not in existence. They can also invoke, my lord, section 2013 Act. So this option is there. If we have to assume that 1964 Act is holding the field, then they have the option of going for two, either of the one. In which case, my lord, there is an option, then this itself is a good ground. But let my learned friend, he is making submission on the basis of 64 Act. And our submission is 64 Act is invalid. It stands repeal impliedly. It is no longer in existence. How can you, by amendment, state amendment of a central act, you can revive that 64 Act? Now kindly see, my lord, under 64 Act, under section 4, you can straight away take possession. Under the 13 Act, to take possession, you must make payment, which you have not received. Then where is that assessment? Where is that public hearing? Well, can there be an argument on behalf of the state that 2013 Act is a cumbersome act? With all respect, my lord, section 2013 is a progressive litigation. In fact, this was a very good
act which has come up in the modern Indian legal history, where the worth of the people has been considered. So therefore, my lord, when 1964 Act itself is not in existence, how a land acquisition proceeding can take place under that act? Let my learned friend satisfy. Has he made one sentence? Why 64 Act is still holding the field? Already saying is under 64 Act, we have taken XYZ steps. Now that's why, my lord, 300A comes into play. You can acquire the land only by authority of law. Now, authority of law, as I understand, subject to what your lordships may say, it is Act of 2030. 64 must give way to 2030. Yes. 281, my lord. 254(1) of the Constitution. 254(1), my lord. Hmm. 254(1). If any provision of a law made by the legislature of a state is repugnant to any provision of law made by the parliament, which parliament is competent to enact. Let us not read the other portions, my lord. Then, subject to provisions of clause 2, law made by the parliament, whether before or after the law made by the legislature of such a state as the case may be, shall prevail, and law made by the legislature of a state to the extent of repugnancy be void. So, my lord, Act of 1964 do not provide any procedural safeguard which 2013 Act provides. So to that extent, this is repugnant. By this presidential accent, which was given in 29/7/64, that is gone with the coming into force of the 2013 Act. Now the present presidential accent is in respect of the state amendment. Now that to kindly see, is it not a very ingenuous way of taking away people's right? They have made state amendment of 2013 Act, and now they want to revive 64 Act. Well, who has made this argument? Where this argument was considered in all these decisions? There, my lord, in Tiny Deka, simply that acquisition notification was put to challenge. Therefore, my humble submission is, my lord, matter is fixed on 27, let it be fixed on 27. Until then, my lord, they should not be allowed to take over possession of the land. And as a matter of fact, today we have not received their compensation also. It does not matter whether they have offered it or not. Therefore, my humble submission is, my lord, subject to what your lordships may say, according to me, my lord, it's an open and shut case. I don't think any extraordinary argument is required. And my lord, this decision in what do you call it, Nagpur development has been reiterated by the Supreme Court in Tarsem Singh in 2019 9 SCC 304. Yes, my lord. No. It was a land acquisition case, my lord. Union of India versus Tarsem Singh. No, my lord. It's a land acquisition matter, para 48, 2019, 9 SCC 304, para 48. Para 48. I can hand over a copy, Miller. Tarsem Singh.
In fact, my lord, if your lordship should recall, originally when 2013 Act was enacted, in respect of some statute, the provisions of 2013 Act was not made applicable. However, there is a provision under section 1113 of the 13 Act that government may by order apply the provisions of the Act. So that is how it was subsequently done. 10, they call it, my lord, the order, there is an order, removal of difficulties order, that they have done it. Lord, I was referring to para 48. It is thus clear that the ordinance as well as notifications have applied the principles contained in Nagpur Improvement Trust, as central government has considered it necessary to extend the benefit available to landowners generally under 2013 Act to similarly placed landowners whose lands are acquired under 13 enactments specified in fourth schedule, that is National Highway being one of the aforesaid enactments. This being the case, it is clear government itself has accepted the principle of Nagpur Improvement Trust would apply to the acquisition which takes place under National Highway Act, and that solatium and interest would be payable under Section 2013 Act to persons whose lands are acquired for the purpose of National Highway, as they are similarly placed to those landowners whose lands have been acquired for other public purpose under the 2013 Act. It was basically a case in the context of, my lord, getting the benefit under the 2013 Act. But here is a case, the procedural safeguard which has been provided by Article 300A has been violated because they have not done it by following a law which is valid. My lord, 2019, 9 SCC 304. Oh, there is another service matter also. Yes, Tarseng Singh. That is Tarseng Singh versus so and so. Yes. Right. So that is my submission, Milord. On the whole, the entire exercise in my humble submission is wrong, Milord. Therefore, some interim protection may be given. My lord, always we do not get an opportunity to argue such matters. My lord, deeply alright.
Only one aspect of the matter, my lord, in Tarini Deka's decision, my lord, which I have, my lord, placed. Lordship may be pleased to peruse, my lord, paragraph 19. Paragraph 19 of Tarini Deka's. There also, my lord, this argument was raised, my lord, that these two acts cannot coexist together. To that extent, my lord, we had relied on two authorities of the apex court, my lord. Yes. My lord, Tarini Deka, my lord, that is 3989. There, lordship may be pleased to see, my lord, paragraph 19, 19, my lord. Paragraph 19, my lord, 19. Paragraph 19. These two apex court decisions we have relied, my lord, to buttress our argument to the extent, my lord, that two acts, one of the, my lord, central legislature and one of the state legislature on the same subject can coexist, my lord, can coexist. Only to that extent.
They can coexist provided both are consistent with each other. That's a very clear cut. Lord, my learned friend, why is he not conceding that in Tarini Deka, the virus of the act was not under challenge? He should be fair to the Honorable Court. Why is he not making that submission? No, my lord, we should be fair to the Honorable Court. We should lay before the Honorable Court facts. Or as far as order is concerned, Lordship will pass. If you feel aggrieved, sometimes you go to the higher forum or else you accept it.
আমার নোটিশ খেলার কিছু দিন আগে ওপেন
One last moderation, my lord, that those instructions, the notices issued under section 7, my lord, were not there with us in the initial bunch of instructions. This is a complete set, my lordship will find the section 7 notices. That much only to that. Yes, of course, of course.
Yeah. Nominee does. No, it's okay.
Notices.
Deep down.
And so obliged.
To the members of the bar, because this has taken some time, the other matters will have to be adjourned. We will be rising for the single bench. Any matter which somebody wants to specifically make a mention?
In the morning, I mentioned for an updation, your lordship, if your lordship is not wishing to take it now, your lordship may fix a date and your lordship.
Yeah. Make it sixth. It go to sixth.
What? Sixth.
Your item number was
29.
29.
29.
Yes, Mr. Mohanto.
My lord, item number 46. Can it be taken up on my lord on 6, my lord?
46.
46. On 6, my lord.
Okay, sixth. 46, make it sixth.
Develop.
Item 40, my lord.
Just wait.
Item 33, my lord.
33.
Very urgent matter, my lord. If possible, tomorrow or on 6th.
It will go to sixth.
6th.
33, sixth. Yes, Mr.
My lord, item number 40, lordships. IAIF file of extension of interim lordships. 40.
Yes, for
40. 40. 40.
this is for
Orders model. 40 lordships.
what is your prayer here?
Prayer lordships, I am praying for listing on 6 lordships.
No, what is the prayer in this application?
Prayer for extension of interim order. It was while issuing a rule lordships directed to appear within the time. Petitioner did not get any information because of contact number was not in order. That's why
When was the order passed?
order passed by
Which date?
17/5/2020.
24. 1 year. Item 40. Okay, next matter, yes.
Well, the item 35, my lord, order. Well, can it be listed on 7th, my lord? The matter pertains to condonation of delay, my lord. You filed a writ petition, writ appeal, my lord, that's barred by.
Notice has been issued, no.
Notice has been issued, my lord, for consideration of
Okay, consideration of the
the interlocutory application.
Okay.
7th, my lord,
35 will be 7.
7th,
Item number
35, then,
35.
35. Deeply obliged.
Brown.
Mr. Borgia, we are not inclined to extend the time. It will be more than a year.
Lordships, that number provided to us, Lordship, was
We
not
can't
in
help
order. Subordination herself
That
came
is
to Guwahati,
something-
Lordship.
That is something we can't help.
Since earlier it was interim Lordship, while issuing rule directed to appear on or before Lordship, but since due to non-ability of the number Lordship, it lost my number also, and her number provided both were not in order.
No, that's okay. That must be between you and the petitioner, the applicant, but so far as court is concerned, 5 and now we are in 11. 1 year, 5 months. No, we are not inclined.
Lordships,
Just
she
give an
herself,
interim production that if
she
you are
herself,
offended, you will not be.
since she lost my number, she herself came to Guwahati Lordship, take information.
No, that's okay. But that is the problem of the applicant. No, sorry, will not be inclined. Yes, you want
My lord.
adjournment in?
Item number 16, if it can be taken up on 11th of this month.
Item
16, 16, addition.
My all Lordship may take up the matter for admission here.
Just a moment. Item 16.
16.
Fix it on 10.
Okay, 16, let it be. Let it be on 10.
10. Yes, any other matter?
Lordship, my one.
Just a moment. Wait, complete.
Item number 13, Lord. Say 2016, right? Can it be day after tomorrow? Today is the second occasion matter remain left over.
We can't help it. For admission. Take it 10th. Item 13.
Alright.
Yes.
My lord, item number 55, my lord, motion matter, my lord.
Item
55, my lord, supplementary 55.
55.
55, my lord. Any date may be given, my lord, either 6th of November or 7th, my lord. In fact, here, my lord, the petitioner has already, my lord, declared Indian, my lord, in another proceeding, my lord.
We can. Okay. Make it Tuesday, 6th.
No.
Okay.
Already.
No, please, also item 56, a date may be fixed.
Item
56, supplementary list.
50,
56.
56. Yes.
Your Lord. A date may be fixed.
This is a motion matter.
Yes.
Same. Yes, now your matter.
My lord, if time permits, lordship, they proceed, lordship, or take up next week, lordship,
No, we'll have time for this application.
or lordship, lordship,
Yes,
here
sir,
is the case, I myself repeatedly tried to inform two numbers provided, lordship, but not found in order.
No, that's
Petitioner
okay.
herself, we
That's-
provided that at the time of
But it's
taking
more
over
than
the
a year.
brief, lordship, but
We are
because of
not
the,
More than a year, we are not inclined.
but only that ground, lordship. But she has to, time to time take information also, lordship, and herself did not get any information since she also lost the number of R. And as she herself came to Guwahati, lordship, and then we informed. My note also here says, I repeatedly tried, lordship, two numbers in my brief also written at that point of time. That is both no, found not in order. Being a lady, that may also be taken because her husband also in the meantime expired also. Husband, okay.
It was the application.
Husband also expired 23/7/19 also.
We can't help it. But Mr. F.P. Borbiel, I'm talking to the applicant and also for the response. Next, by filing this interlocutory application, the applicant, namely Musammat Amina Khatun, has prayed for extension of time granted by the order dated 17/5/2024 in WBC 388 of 2018 to take bail. In terms of order dated 17/5/2024. Next. The learned counsel for the petitioner has submitted that after the passing of the order dated 17/5/2024, he had made an attempt to contact the applicant in the two mobile numbers provided, but both of those mobile numbers were invalid and therefore the applicant could not be contacted to inform about the order dated 17/5/2024. However, in the meantime, the applicant met her engaged counsel and got information about the directions contained in order dated 17/5/2024 to take bail. But by that time, by then, the time granted for to take bail has already expired. The learned counsel for the applicant has also submitted that in the meanwhile, the husband of the petitioner had also expired, applicant has also expired, and the applicant could not approach an engaged counsel on time. Next paragraph. Have you noticed that despite order dated 17/5/2024, passed in WBC 388 of 2018, the applicant has not taken bail, nor he has approached this court on within a reasonable time for seeking extension of time to take bail, or the court is not inclined to extend the period to take bail. Nonetheless, it is provided that in the event the applicant, namely Amina Khatun, who is the petitioner in connected WBC 388 of 2018, is apprehended, she shall not be deported out of the country without order of the court. Lead petition, you say both sides are represented as the court is basically trying to extend the period, the time to take the right order passed in IS Civil 2617 of 2025, comma. The hearing of the matter is expedited. List the matter for hearing on 25/11/2025. Special case time 25/11. Okay, we are fixing it for hearing 25/11.
Yes, sir.
Expediting the hearing
Next week, Lordships,
25/11.
25. Obliging.
213/25.
Your objection has not come.
Lordship, no. Sir, in spite of corporate, we could not receive
Pardon
any.
me?
We have not received any reasonable objection from the department.
We got the records.
I'll submit orally, Lord.
Hmm?
Orally, I'll commission make.
So these records have again not been. Has he? मुझे रिकॉर्ड को आना है ना रिकॉर्ड को खोल अपना देखिए just wait for some time. That record has not been fact. Just wait for some time. That's एक double chamber. Yes. This review petition number, item number 2.
May I please, Your Lordship?
Yes.
Well, I am recently engaged, but that I could not go through the records of the case.
But
Yeah,
there's a
so
last
I-
order we say that it will not be adjourned. Since it's a old pending matter of 2017. And what has happened to the proceedings of the title appeal? Proceedings of title appeal, what has happened?
It was remand back, Lordship.
What has happened to that proceeding? What is the status of that proceeding?
Yeah.
Hmm?
My lord, I am told that the stay order has been passed in the review application. Stay of the appeal has been passed.
Oh, the proceeding has been stayed.
Yes, sir. Lordship, in this case number 180/2017, stay order has been passed, Lord.
Just a moment.
Order dated 28/2/2018, in this case 180/2017.
This, who is appearing for Samsul Hussain and Abdul Rao?
And
What is answer?
we are appearing for Samsul Hussain, Lordship.
You are appearing for Samsul Hussain. And who is appearing for Abdul Rao?
Abdul Rao,
No
the
one is.
respondent.
No, I think
No one is opposed.
No, it's a petition on the Bapek.
Abdul Rafi is not represented, madam. The
Abdul Rao is the father of the people.
This review petition is by Rezaul Hassan and Kamrul Hassan.
Yes,
Who is appearing for them?
we are appearing.
You are appearing. So you will appear for Abdul Rao also.
He has been made a party respondent in this case.
Hmm?
But as he did not contest the malad, title suit malad in proper perspective, as he has been made a party in his review
No,
petition.
he's not been made a party. He has filed an application for impleading.
Yes, madam.
Samsul Hussain.
Samsul Hussain died, my lord. His legal hairs are there, my lord.
Samsul Hussain died.
Yes,
my
Lord.
lord.
Samsul Hussain is the respondent in the, in this, in the,
Was the original plaintiff, my lord.
so in the review petition, he is the respondent.
Respondent, Lordship.
You are for him.
I am appealing for his legal.
Has he been substituted?
Yes, my lord. Substitution petition we have filed, my lord, that notice was issued.
IA number?
Hmm.
869, ma'am.
Hmm?
869, ma'am.
Hmm.
869 of 2022, my lord.
$869.
My lord.
These applications were never moved. In this process, your cases would never be heard. The substitution has not been allowed.
We allow the substitution petition by law.
Who's appearing for Samsul? You are appearing for Samsul Hussain. Any objection to the substitution?
No.
No. 869. But
So
Mr.
there are two,
Journalist
Madam,
Council
there are two
assisted
applications.
by Saikal and Council for the applicant, as well as Mr.
I Ahmed.
I Ahmed, Learned Council appearing for the respondents. Next paragraph. By filing this, this interrogatory application was filed on
603.
Well, I want to, there are two petitions, another for condonation of delay.
where is that?
IA number 868 and 870.
It is condemnation for delay.
For substitution, there is delay, my lord.
868 and
Information letter
870.
only. That will be displayed first.
Condonation of delay and
Is the delay of
603 days, Lord.
603 days. Is any objection to that?
Lord.
Yes, no. But Mr. Mr. Spencer, we have already said, Spencer and for the respondents. By filing this interrogatory application under section 5 of the Limitation Act, the applicants who are the review petitioners have prayed for considering the delay of 603 days beyond the period of limitation in filing the connected interlocutory application for substitution. The explanation of delay is that the applicants were not aware of the death of the sole respondent who had died on 25/6/2018.
Lordship, it is not 25/6, Lordship, it is 7/6/2018, Lordship.
7/6/2018.
Wrongly typed. No,
Very wrongly.
wrongly typed. Lordship, I don't know. The death certificate is there, Lordship. Death certificate, next one, Lord. 7/6/2018. In 860.
Page 10.
In eight. Date of date is. In IL Lordship 868, page 10. Date of date is 7/6/25. But 18.
7/6/18.
Yes.
The statement is wrong. Now you'll have to file an application for amendment. And you'll also have to file an application for amendment because otherwise this will be dismissed. Now look at paragraph 3 and paragraph 7 of this application. Take a, yep.
paragraph again.
All left blank. Another paragraph also, there is blank. That's right, left blank.
Paragraph 9 has a-
Paragraph 9, but delay has been incorporated paragraph 3.
But if you don't fill it up, it's not a statement of laws.
My lord, we will file a,
You have not
Uh-huh.
had an application for amendment.
Yes.
Stop. At this stage, the learned counsel for the respondent has raised an objection to the effect that as per the death certificate appended to the appended to this interlocutory application, comma, the date of death was 7/6/2018 and not 25/6/2018. So it is also submitted that the statement made in paragraph 3 and 9 of this interlocutory application is incomplete.
7 also. 7 also.
7 and 9.
3, 7, 9.
3 and 9 of the application is incomplete. Next, accordingly, the learned counsel, the senior counsel for the applicant prays for a week's time to file an appropriate application. Next. Applicant should do the needful at the earliest in view of the fact that the statement is made in the bar owing to the interim orders passed in this in the connected review petition, comma, the proceedings of the first appeal. First appeal.
second appeal.
No, it was sent.
That is
First appeal.
First appeal.
First appeal has been stayed. The accordingly, the current counsel for the application do it within how much time?
1 week.
1 week, within a week's time. List the matter on 1/12/2025.
My senior. 13 নহলে 27 লাগবে।
Right, very.
কিমান দেখবে?
But do the, for this review petitions pending for so long doesn't look good.
Yes, sir.
We don't want to keep it adjourned. We've given you a long time, 1/12. Try to do it on that day.
1/12.
Be prepared for everything, the interrogatory application as well as review on merit.
1/12.
1/12, my lord. 1st December. Right. 1st December.
The both sides shall be prepared for the entire matter to be heard on the date, including this interrogatory application as well as the connected applications and the review petition.
Obliged.
Item 1.
Yes.
Please note indicates that officer received the scan copy. Scan copy is called for, that is been received by receipt.
May it please your lordship.
Yes.
My lord, here petitioner is in jail for last 2 years, 10 months, last, my lord. And at page number, my lord, at 68, my lord.
Yes.
Yes, my lord. Here, this is an application by the co-accused, my lord, arrested on the same day and forwarded on the same day, my lord, and with the same ground of arrest. Similar ground of arrest, my lord, and page number 68, my lord, starts, my lord, and finally, my lord, at page 77, 78, my lord, operational age, the co-accused was enlarged on bail, my lord, on the ground that the grounds of arrest were not properly, my lord, intimated, my lord. That is violative of section 50 of the CRPC, my lord, and 52 of the NDPS Act, and 21 and 22 of the Constitution, my lord. My lord is aware of that, my lord.
Yes.
My lord, from the paper book, copy, my lord, supplied to us during the trial, my lord, I have gathered, my lord, the notices under section 50 CRPC to all the three accused are the same, my lord. I mean, I am having that, my lord. If your lordship want to say, I can place.
Wait to Mr. Kyal. Lordship. Wait to Mr.
Yeah.
Kyal.
I've seen, Lordship, they have annexed at page 67.
That is same words are used in, my lord, Monirul case also. So, my lord, without taking much time of this honorable court, my lord, the ground of the primary ground for, my lord, praying for the bail is, my lord, that same is the case with the co-accused, my lord, who has been released by this honorable court, and same footing, my lord, same forwarding, and arrested on the same day, my lord. This is, my lord, my primary ground, my lord. If your lordship, my lord, call for, then I can, my lord, give the there are many rulings of the Honorable Supreme Court, my lord, that I can put it before your lordship, but lordship already aware of. That is why I'm not, because I have seen.
Do it because I don't remember anything.
Yes, my lord. Yes, my lord. It is, my lord, I have just said to the.
Give the paragraph numbers also. Give the paragraph numbers also.
Yes, my lord, I have given.
Yes, Mr. Kyal.
Yeah.
That's all.
My lord, that basically, my lord, that one, I've seen, my lord, this honorable court also has relied in 3-4 cases, my lord, here, while granting that 150, my lord, section 50 of the CRPC, my lord. Basically, my lord, this Rihan Kumar versus state of Haryana, that was given, my lord, weightage. That part, my lord. I have just, there are innumerous, my lord, decisions, but I'm
Give
putting,
the paragraph
yes,
number.
here I'm putting the paragraph, my lord. My lord, other than that, two grounds, my lord, another two grounds are there, my lord. One is this, my lord, that almost 3 years, only 1 month left, my lord, is in the custody, my lord, and only till now, my lord, 4 witnesses have been examined. And my third ground, my lord,
Yes.
first ground is that, my lord, 50 CRPC is not complied, 52 of the NDPS not complied, and Article 22 of the Constitution of India was not complied. This is my first ground, my lord. And on that basis, my lord, co-accused has been released on bail by this honorable court, having same footing. This is my first ground. Second ground is, my lord,
Yes.
second ground is, my lord, the length of detention. That is already is a reason. And third ground would be, my lord, only 4 witnesses has been examined. And out of that 4, if your lordship ask me, I can read I have annexed those statements, my lord. Not a single iota of evidence against me, my lord. Not a
Evidence
single
being
word.
examined right now.
Yes, yes. 4 witnesses, my lord, including the informant, my lord. Nobody has said anything about me. That is my lord, subsidiary grounds. Basic ground is, my lord, that that grounds of detention are not complied with. And on the same ground, my lord, my co-accused has been granted by this honorable court. I pray for parity, my lord.
Yes.
And in the honorable court, my lord, the co-accused state that bail, my lord, page number 76, my lord. Just I read, my lord, only these 2 paragraphs, my lord. In the instant case also, that Vihan Kumar case was discussed, my lord. Page number 76, paragraph 16. In the instant case also as discussed above, it is seen that there is no mention of grounds of arrest in the notice issued by the present accused petitioner under section 50 of CRPC, and except the name, address and the case numbers, there is no mention about any other particulars of the offense as well as ground of arrest. So from the proviso of section 50 of CRPC, it is seen there is clear violation of the mandate of Article 22(1) of the Constitution of India, and in such cases, in spite of the statutory restriction under section 37 of the NDPS Act, this court is of the considered opinion that for the violation of the constitutional mandate contained under 22(1) of the Constitution of India, the arrest of the petitioner is vitiated, and it may be sufficient ground to consider his bail application in spite of rigor of section 37 of the NDPS Act, which provides restriction in granting bail in the case of commercial quantity under the NDPS Act. The Honorable Supreme Court in the case of Vihan Kumar has also held that even after filing of the charge sheet, the arrest and the detention will be considered as unconstitutional, being violative of Article 21 and Article 22 of the Constitution of India. The Honorable Supreme Court in paragraph 16 of the said judgment has held as under. An attempt was made by learned senior counsel appearing for the first respondent to argue that after his arrest, the appellant was repeatedly remanded to custody, and now a charge sheet has been filed. His submission in this is now the custody of the appellant is pursuant to the order taking cognizance passed on the charge sheet. Accepting such argument with great respect to the learned senior counsel will amount to complexity, nullifying Article 21 and 22 of the Constitution. Hence, it is held that the arrest is unconstitutional due to violation of Article 22(1), and the arrest itself is vitiated. Therefore, continued custody of such a person based on orders of remand is also vitiated. Filing a charge sheet and an order of cognizance will not validate an arrest which is per se unconstitutional, being violative of Article 21 and 22(1) of the Constitution of India. We cannot tinker with the most important safeguards provided under Article 22. In the same time, it also cannot be denied that the accused petitioner is behind the bar for more than 2 years and 6 months from the date of his arrest until that the prosecution could examine only 3 witnesses out of 12. listed witness. And it also cannot be denied that the prosecution may take considerable time for examining the other witnesses. In view of the entire facts and circumstances as discussed above vis-a-vis non-mentioning of grounds of arrest in the arrest memo, as well as in notice issued by the present accused petitioner under section 50 of CRPC, and also considering the period of incarnation already undergone by the accused petitioner, that is 2 years and 6 months, as well as considering the view expressed by the Honorable Supreme Court in a case laws referred in herein above, the court finds a fit case to extend the privilege of bail to the accused petitioner. Accordingly, my lord, I humbly submit, my lord, my case is absolutely in the same foot with this accused petitioner, my lord, co-accused, my lord.
Yes. Let's see, before this application, 4 times the petitioner applied this honorable court twice, and before that trial court. Let's see, page 22.
Each number?
Page 22, the bail application.
22, yes.
It was before your lordship, bail was rejected. Then lordship, page 25.
45.
25. 25.
25.
By this honorable court. See page 27 before the trial court. Again, this honorable court on page 31, there was rejected on 16 to 24. Page 31. Then it's page 46. Fifth time. This time bail application was filed, but after a long time, let's say it was withdrawn on 9/6/2025. And this is a sixth bail application in row. Lordship, with regard to granting of bail to co-accused, Lordship, here probably Lordship may remember for 1 year the bail application filed by Moinul Islam was pending before Lordship, but suddenly it was withdrawn and it was moved before another court. And to that effect, Lordship, we have filed a complaint before the Honorable Chief Justice, taking ground that this is a unique case of bench hunting. Now, Lordship, now my learned friend has taken a ground that section 50 or 50A has not been complied with. In the respect, Lordship, I am placing one judgment passed by your Lordship. In co-accused bail application, this ground was taken. It was rejected on 16/6/2025. Lordship, paragraph 15 onward. Same ground of arrest, same notice under section 50. Paragraph 15, the content of the memorandum of arrest dated 18/12/2022, respect of NCV crime number so and so, and content of the notice under, the lordship contents have been quoted. Then section 50 notice has been quoted. As per contention of the charge sheet, the contraband, narcotic, drug and substances were recovered from the house number so and so. From the content of the memorandum of arrest for reason of arresting have been fully disclosed. At this juncture, it would have been relevant to quote the provisions of section 50, that 50 has been quoted. Therefrom, section 47(1) of BNSS, the requirement of law is that on arresting a person without warrant, every police officer or other officer arresting any person without warrant is required to communicate him full particulars of the offense for which he is arrested or other grounds for such arrest. The same is also prescribed in section 50 of CRPC. Then 20, therefore, though the learned counsel for the petitioner has made a very strenuous argument to impress upon the court that non-pronouncing of the ground of arrest would fatal and has supported his submission with several case citation. But in this case, the content of the memorandum of arrest is specific to the petitioner and give the description of the offense for which he has been arrested, and it also contain the section of law based on which the petitioner has been arrested. Thus, from the content of the memorandum of arrest, as restricted therein before, the court is of the considered opinion that the document contains the full particulars of the offense for which he is arrested, which is a scrupulous compliance of the provision of section 50 of CRPC, which is near parametria to the section 47(1) of the BNSS. The same also found in compliance of section 52A of the NDPS Act. Paragraph 21, the provision of section 51 of CRPC and section 47(1) of BNSS have been quoted herein before. The requirement of law under both the provision is that the arresting officer is required to communicate to the arrested person full particulars of the offense for which he is arrested or other grounds of arrest. The used word or cannot be interpreted under any canons of interpretation of statute to be read and as to mean that not only the arrested person is required to communicate a full particulars of the offense for which he is arrested, to also communicate to other petitioner on the ground of arrest. In this regard, the court is of the considered opinion that the word statutory provision must be understood and read in its plain and ordinary meaning, which is golden rule of interpretation. Therefore, the use of word or in between the communicate to him full particulars of the offense for which he is arrested and other ground of such arrest must be interpreted that communication of either of the two would sufficient and or that the ground of arrest is interchangeable use by communications of full particulars of offense as appearing provision section 51 of the CRPC and section 47(1) of the BNSS. Then section 52 has been quoted. Then paragraph 24. From the perusal of the above quoted provision of section 52 of the NDPS Act appears that the departure from section 51 of CRPC and section 47(1) of BNSS, the requirement under section 1 of section 52 of NDPS Act is that any officer arresting a person under section 41 to 44 of the said act is required to inform the arrested person of the ground of such arrest. In this case, a memorandum of arrest was provided to the petitioner on 18/12/2022, which is quoted herein above before. The same amounts to informing the petitioner of the ground of such arrest. Accordingly, the court is of the considered opinion that the content of the memorandum of arrested, which is restricted herein above, there is thus compliance of communicating the petitioner the ground of arrest. Thus, in the light of the discussion above and on discussion of the case cited by the learned counsel for the petitioner, the court is considered opinion that the providing petitioner the memorandum of arrest on 18/12/2022, the petitioner has been communicated the ground of arrest. It contains the description of huge quantity of drug and psychotic substance seized, the provision of law, contravened the petitioner for which he has been arrested. The said memorandum of arrest is specific to the petitioner. Insofar as the consideration of bail on the merit, Lordship, so Lordship, section 50 is clearly stipulated that person arrested be informed on ground of arrest and right to bail. Lordship, he has not less than 6 times approached different forums. 5 times this honorable court, 1 time before learned trial court. So compliance has been made, Lordship. And his family members were informed of the ground of arrest. Lordship, my learned friend is annexed only section notice under section 50. These are the documents, Lordship, provided to the petitioner, Lordship. The same memorandum of arrest has been quoted by your Lordship. Lordship, please to see the below the signature of the accused is there. Then intimation of arrest of Atikur Rahman was.
No, but these things, Mr. Kyal, has to be brought on record.
Lordship,
Because otherwise, if the order goes against Mr. Hazarika, he will be prejudiced.
Lordship, then.
He'll have no remedy except for. Because now if he has this, he can take instructions and argue before the court. He may have this, I don't know, but
Lordship, Lordship, allow me 4 days time, I'll place on the record.
otherwise he'll suffer prejudice.
That this I have to check, my lord, I am not aware of.
Because
That's
he
right.
is having all the document with him in his
No,
paper.
maybe, you see,
No, Lordship,
maybe Mr.
I'll,
Hazarika is having it, but still,
I'll-
once you are producing this, he must have a copy.
Lordship, allow me 4 days time. By Friday, I'll file up. Let me take the matter on Monday, Lord.
Because it's a issue of fairness.
Lordship,
He must. Raji, want to say? Somebody go. Both sides are represented. In course of his submissions, Mr. S.C. Kyal, learned standing counsel for the NCB, has produced certain documents for the purpose of showing that the petitioner was aware of the ground, of the reasons of why he was arrested. Full stop. If the state intends to rely on the documents that the same we formally filed, so that the learned counsel for the petitioner has an opportunity to address the court on the same. Stop. Those documents shall be brought on record by 7/11/2025. List again on 17/11/2025.
Much.
There's some uncertainty. I may not be available in the next week.
Lots.
Oh. Okay.